Happy Tuesday. It's time for coffee, or in this case, cold brew. It's time for cold brew and cursey words. That's what we're doing. That's just what we're doing today. There is so much on today's docket, and I'm looking at my notes going, this is going to be a lot. Just bear with me. The thumbnail for today's video is not clickbait. I sat last night and recounted multiple times. There are 105 new lawsuits in the Girardi Keese bankruptcy. I'm not joking. 105 new lawsuits. We're going to talk about what those lawsuits are, but it's not just that. It looks like some of these attorneys are anticipating imminent criminal charges, and a case just got stayed because, in my opinion, even though a lot of it was under seal, the judge might agree. And then, so that's like Girardi. We have the ex-CFO staying in custody. We have 105 new lawsuits, including against Erika Girardi and her son. Yeah. And then we have this pending, imminent, potentially criminal charges. And then we have a whole bunch of quick bits. I put up a poll. If you haven't voted, vote. We are talking about Jen Shah's sentencing. We'll talk a little about Camille Vasquez and her new job. We're going to talk about the big Nirvana Baby. Oh, that case, we thought it was done, but it's the new year. It's 2023. Nothing's done. And then we're voting on whether we're talking about the Chrisleys updates. So if you're like, Emily, you can't get through all of this in one live stream, bet. I probably can't. We're not going to go through all 105 lawsuits. I have a way that we're going to summarize it and explain what it is. But oh my goodness, should we just roll the intro, the new intro? Hopefully it's not too loud. I think we're working on it. Look, work in progress. We're all doing it together. Why? Because we're professionals here, people. It's Tuesday. Let me know where you're coming in from. It's so good to see you, Law Nerds. Let's go. Hey there. I'm Emily D. Baker, everyone's favorite legal analyst, breaking down the legal side of the pop culture stories we can't stop talking about. I've been a licensed attorney for over 17 years. I'm a big fan of the cursey words. And remember, this is not legal advice. Okay, it's time. Let's just get into it. I mean, the new intro is a work in progress. I know we love the cursey words intro. Leanne G, I love the cursey words intro too. And do you know what YouTube said? YouTube was like, hey, what you can't do in the beginning of your videos at all, ever, even a little teeny tiny bit, is play with the cursey words. So don't worry, we are still a cursey word friendly stream here. And sometimes YouTube is not cursey word friendly, but a ton of people had issues with having videos demonetized. And I rather try to play nice where I can so that I can push back where I need to. So I also wanted to shorten our intro just a bit so we can just get into it, because replay crew, love you, but I can see the analytics, replay crew. I know most of you aren't bopping to the intro. A lot of you are like, skip, which is completely fine. So I wanted to honor both our live audience and our replay crew audience. It's so good to see where everyone is coming in from. Thank you for coming at our slightly later time today. Jessica's like, it was a business decision. It was. Don't worry. We're still going to drop all of our cursey words just slightly later in the show. So I'm just not worried about it. Ryan's like, people who are adults aren't afraid of words. No, but the YouTube robots are afraid of words. So we're going to work on it. But a lot of channels got hit really hard. Ours, really, truly not too badly. And sometimes it feels weird when I say ours, but it's ours. Does not playing the full intro when on replay penalize you? No, not at all. I can just see it on the analytics, which is why I'm like, I need to, we'll tighten it up. Look, it's going to take me a lot longer to tighten everything else up in the new year, so we can tighten up the intro real fast. Bree Cup said, today is my son Sammy's 9th birthday. Can he get a shout out? He would love a YouTuber saying happy birthday to him. Sammy, my 10-year-old, says I'm not a full YouTuber yet because my YouTube subscription number only has a K, not an M, and Mr. Beast and Technoblade and all the other YouTubers that he really likes have an M after their number. So hopefully you'll accept this kind of YouTubers' happy birthday wishes. So Sammy, happy birthday. And we should get into it. You know why? We literally have so much to do. So we're going to talk Jen Shah first. you guys are just going to go into Pacer with me. There's a lot of notes. There's stuff we can't download. So you're just going to come with me into Pacer and we're going to talk about it. Pacer is the court system or the online system where we can look at court documents together. And then we're going to do so much more. So let us get into it. You know what we're doing today? We are doing quick bits. It's been a minute. Keep voting on the Chrisley poll. We'll add that as the last story if the poll says yes. We're letting the law nerds decide. We're letting the law nerds decide. So we will see. I'm already seeing requests to bring back This Is Where Law Nerds Unite. I'm open to request and notes. I am. I'm saying it's a work in progress. We're a community. We get to decide these things together. I'm open. I'm absolutely open because this is where the law nerds unite. And I could just say to talk about facts. Let's get into it. We could just let it hang, and that might be really funny. Y'all, thanks for workshopping this with me. It's so much more fun doing our work together. All right, let's go. Let's get into the quick bits. Quick bits! Y'all are like 2023. Who this? I know. We got all kinds of new stuff for you on the channel, and I am here for it. Let's talk about Jen Shah's sentencing. Have you been following along with Jen Shah's sentencing? I have. So on Friday, January 6th, Jen Shah, and if you don't follow me over on my Quick Bits channel or over on socials, you might not have seen my Quick Bits about it. So here it is. With Jen Shah's sentencing, she got 6.5 years in federal prison. Has she turned herself in yet? No, she hasn't turned herself in yet. Will she be turning herself in? Yes, on February. Oh, my mic volume is really low. Sorry, y'all. That was an Emily issue. Thanks. That was an Emily issue. The Quick Bits bumper seems loud because Emily's mic was turned down. So 6.5 years, $9 million in restitution, $6.5 million in forfeitures, plus 5 years of supervised release when she gets out. So yes, it doesn't feel like 6.5 is 14, but it's kind of in the middle, and I appreciate it's kind of in the middle, because it's kind of in the middle. So the government was asking for 10. Jen Shah's attorneys were asking for less. Jenny, members only mode is not turned on, so the chat should be on. I'm seeing comments from non-members, so the chat should not be on members only because I am seeing chats from everybody. So it shouldn't just be members. It should be on subscribers mode. So I see lots of chats from non-members. So if you're not able to chat, you might need to double check. But sometimes that's just us, on the back end. We set it to members only in the pre-show. So sometimes that's just us. So no, it's not an intention that we're doing it. Sometimes we just forget to put it to subscribers mode. So thank you. Thank you all. We've sometimes it's a little busy. All right. Thank you, chat. We're always here. All right, perfect. Thank you all. There you go. It's generally us forgetting things because we do that. We do that sometimes. So it went off earlier. See, sometimes things happen in the back end. That's okay. We are professionals. I need a bumper for that. We need a sound. What is our sound for we are professionals? We are professionals. Emily, why do streamers stream for so long? Because they've got to get through all the bits that are not content. So, Jen Shah's sentencing, 6.5 years, 5 years of supervised release after, which is like a probation. She has to check in with people. There's a lot of terms for that. Then 6.5 million forfeited. The government comes in and takes your stuff up to $6.5 million, or they substitute stuff like, oh, well, we don't know if this is from crime proceeds, but you have that, so we'll take it. Yes, that can be garnishment of wages. Yes, that can be garnishment of future earnings on housewives or anything she hasn't been paid. But yes, that can also be towards anything, that comes into her household. So 6.5 million in restitution, not in restitution, 6.5 million in forfeitures where you can get your stuff yoinked, then up to 9 million in restitution. She's going to owe. There's no way around that. The government dropped a lot of hints that Jen Shah maybe didn't notify the IRS of hundreds of thousands of dollars. So I imagine that's going to be incoming. Like that's the other shoe that's going to drop potentially while she's in custody. that can't be an exciting thing for her. And her husband is an attorney or is trained as an attorney, has worked as an attorney, even though he's coaching football now. And I'm never going to shade an attorney that's left traditional practice. I talk on the internet about law with purple hair. No shade. But he should know that when the government is putting in all of the documents that there is hundreds of thousands that was not reported to the IRS, that the IRS is like, oh, hi there. We're the IRS. We would like to know where that hundreds of thousands of dollars went. You should be paying taxes on it. And then we're going to add penalties. And then we're going to add all the other stuff. So with that, the government entities will end up fighting over who gets what and when. So Jen Shah's sentencing, that's it. That's all she wrote. We will see additional information. Inner City Press, who has a great account over on Twitter, who covers a lot of news, particularly in and around the federal court in New York and other locations in New York, was in court for this, did a great breakdown. Later, there will be a transcript of the sentencing that we will have access to. A bunch will happen before that, but we will have access to that down the road. If anyone's still interested, I'll ask. We'll do a poll and we'll go for it. We will also get more information from Jen Shah's sentencing when it's in the court file, because Inner City Press objected to all of those redactions. You remember her sentencing memo? It was like, Jen Shah, this black line, then this, black box, then this, redacted. Well, they've objected to the redactions, so we should get some more information coming out of that sentencing memo when the court unseals it. Hopefully that will be soon. We're going to go over to Pacer. Emily, is your screen share pulled up? Let's not get like wild. All the way pulled up. One of the things I love about Pacer is different jurisdictions are different colors. So when you're switching between different courts, like if I switch, this is Georgia, this is New York. When you switch between different screens, they're kind of color coded, and it makes my heart so happy because as a law student and still as an adult, I color code almost everything. So I visually, my brain has a switch between the kind of information that we're looking at, so that we get in Pacer as well. Because if we look at the Chrisleys case, I wanted Pacer to be pulled up. And I haven't pulled those documents yet because stuff just happened this morning. So, all right. And because yesterday when I was pulling through Pacer for what I thought were a few cases, there were 105. It took me a little bit longer than I was anticipating. By a little, I mean a lot. Judy asked the real question, can Jen write a book and keep the earnings from it? If she writes a book, she can't profit off of her crimes. The court has made that very clear, and it's very clear. If she writes a book, the proceeds, she won't get to keep all of it. No, some of it will have to go to restitution. So it's a very good question. All right. So we have, let's see what's been updated. We have a motion from Joseph Minetto for the adjournment of sentencing. So this sentencing is getting put over again. That's a co-defendant. Then we have Joseph Minetto. Let's see. What is this? From January 10th. Address the judge, dated. This letter is submitted to request that sentencing proceedings scheduled for January 12th adjourned to mid-April. Something's going on because a couple of these sentencings have gone over to the same date in mid-April, and I'm wondering why. It will become apparent to us later, but something's going on. And I wonder if we will see Stuart Smith. Getting sentenced around that time too. So we are seeing that going over to mid-April. This is a preliminary order with forfeiture. So this is going to talk about the things that got pulled from defendant Chidi. This is consent to restitution with regard to that same, different defendant, Damon Williams. This is forfeiture. This is order of restitution. So we don't have any of those documents on Jen Shah yet, but we do have a sentencing for the co-defendant Anthony Chidi for counts 1 and 2. Defendant was present with attorney. Let's see. Defendant is sentenced 6 months in custody on each count to run concurrently. So that's 2 counts. So that's a year. So this defendant is sentenced to a year, followed by supervised release for 3 years on each count. So 6 years of supervised release with standatory. Forget standard and mandatory. It's now just standatory with the standatory conditions. Standatory conditions and special conditions. 6 months home confinement. Oh, so that's really That's really 6 months in custody. 6 months in custody, unless they've already done time. If they were arrested and have time served, this might be no additional time in custody because this is 6 months home confinement and they only got sentenced to a year. So 6 months home confinement, search, no new credit, no access to financial information, risk notification supervised by district residents, make restitution payments, special assessment, restitution of 6.6 million, forfeiture of 4.25 million. This is a pretty high restitution. Defendant shall surrender to serve a sentence on March 10th. So it looks like they're only going to be in custody for about 6 months and then 6 months home release. So 6 months actual confinement with credit, 6 months home release, and then 6 years of ongoing monitoring to ensure that they adhere to conditions, don't reoffend. So I love the chat. It's standatory, Elaine. Exactly. So that's what's going on with Jen Shah. More to come, but not a ton. I think the thing I'm most interested to see is if she will get assigned to that minimum security prison camp in Texas that everybody's been asking to go to. By everybody, I mean, Elizabeth Holmes and her. That's now everybody in my world. So the sentences that we've followed. All right, let's move on to this announcement with regard to Camille Vasquez. Where did I post that story? Oh, I posted it on Twitter. Have I been posting and ghosting on Twitter? Maybe a little bit. I only engage with the law nerds really on Twitter, and then I'm like, I'm out. So this is coming from the Hollywood Reporter. Let's pull that up and swoop. You know the name from the Johnny Depp Amber Heard defamation trial. Camille Vasquez, attorney for Johnny Depp in defamation trial, lands TV gig with NBC News. I was surprised and happy to see this. I was surprised it was NBC. I mean, if you remember, NBC aired those interviews with Amber Heard that I was maybe a bit critical of. NBC edited some of those sentences out. Like they aired the clips and then the final edit, like those sentences were pulled out, like they franken edited full sentences. It was fucking scary. It was so wild to me. Steve is asking, what's my necklace? Is it Illuminati? No, Steve. It's a Louis Vuitton necklace. I mean, unless Vuitton's the Illuminati. We're lucky it doesn't also have Starbucks and Apple on it. No. I'm glad it's weird in your opinion, but it's Vuitton, not weird in my opinion. I bought it for myself for my birthday. So we saw those Franken edits from NBC, which was a really interesting thing. We saw NBC print being fairly critical of Johnny Depp. So it's interesting that this is where we're getting Camille Vasquez landing. Foxy Project, the reason I bought it is because it looks like a Triforce. That's literally what I loved most about it, is that it looks like a Triforce. JJ's like, Emily needs a TV gig. Here, let's not put that too much into the universe, because here's the thing about TV gigs that y'all might not know. They start really early in the morning. They also put their cameras down really low. Like my YouTube camera, because I'm in control of everything, because this is my office and I set up my camera and my lights. And so sometimes when things go awry, it's like me. I'm the one who's made things go awry. But my camera's up here. And then it shoots me from this angle that I find very much more flattering than a camera that's put way down low and is shooting like up into my chin and my nose. It's awful. And it's early. It's very early. Anyway, so thank you. I'm happy to be like a guest star. We'll happily come in and give comment, and I've done that quite a lot. But we'll come in and give comment, but I don't know if that's really what I want. I love doing this with y'all. There's no live chat on TV, And chat, say it with me. Chat is bae. Well, I don't have nose hairs anymore, but you'll hear more about that if you listen to my podcast. A lot of you know. I also don't like dealing with corporate politics. I really don't do that well, and I don't do well being told what I can and can't say. The other thing is I really like long form. It's very hard for me to be succinct. It's hard for me to give the information that I feel is thorough in a 2-minute clip. While some people do that well, I find that it leans into not giving all. It just gives the headline of the information. What I really like doing is giving you more than just the headline of the information and giving you all of the information. So we will never say never, but things being what they are. Let's look more at this. So Vasquez will be a legal analyst for NBC News and made her debut Monday. Camille Vasquez is joining NBC. The attorney who represented Johnny Depp in his defamation trial against Amber Heard has inked a paid deal as a legal analyst for the news division. Vasquez made her first appearance for NBC on Monday morning discussing the Idaho college student murders. Vasquez, a partner of Brown Rudnick, secured a significant $15 million win for Depp that he then settled. Last month, Heard settled the case with Depp, ending any pursuit of an appeal. For like $1 million, they didn't note that. The trial, which was broadcast publicly and covered live by TV networks and on social platforms, turned Vasquez into a household name. As the trial ended later that summer, the lawyer who was pursued by both other law firms, she was promoted to partner at Brown Rudnick, and by TV news outlets interested in her services as a contributor. The Hollywood Reporter has heard at least 3 national news divisions had inquired about her reception to an analyst or contributor role. It appears NBC won the battle. Apparently, Vasquez was asked about internet sleuths analyzing the Idaho murder case. One TikTok star is being sued by someone that they named as possibly being involved. Here's the thing. That maybe downplays what that defamation lawsuit says. I cover that in tomorrow's podcast. That maybe downplays what that lawsuit says. It's not that she named, the TikToker didn't name someone as possibly being involved. The TikTok said this person hired someone to do this thing. Oh, and this is the person they hired, and this is the reason. It was a whole thing. That's tomorrow's podcast. It is inconceivable. Just inconceivable. It's a topic Vasquez knows well, with the Depp Heard trial dominating social media. This has become something that really captivated the country. This case has, Vasquez said. And so people want to talk about the evidence. They want to talk about the human impact. And these are college students, right? I think it can be helpful to investigators. They pleaded to the public and asked for information about the murder suspect's white Elantra, but it can also be harmful when you start naming someone. I don't disagree with that. So it'll be interesting. I think this is where we are seeing law firms really probably happy. I imagine Brown Rudnick is thrilled to have the law firm name continue to be in the media through someone like a Camille Vasquez. She's a young attorney building her stature and career. And this is one way that attorneys can continue to build. Civil attorneys need to bring in clients. One of the ways they do that is being on TV. And a lot of civil attorneys, when we talk about the behind baseball look, when I left criminal law and started working in consulting and looking at how these things work, people will pay for radio shows. They pay to have time on radio. They pay to have time sometimes on television. They pay to have appearances on certain podcasts. That's not always disclosed, but a lot of attorneys do this as marketing. Camille is being paid for this while also doing it as marketing for the firm. I think the firm is going to be thrilled with this next move. I really do. And I think it's a good way for Camille to continue to grow herself. And this is what we're seeing so commonly in larger media, is not just does the statute of the firm grow, the statute of Camille Vasquez grow, but we see people kind of growing themselves as well as growing their career, and having a recognizable face and name is something that's inevitable for her at this point. So why not trade on it? I'm not mad at her at all. So I see everybody asking, is this instead? No, this is in addition to. I imagine that we saw her in New York in studio on the Today Show. I imagine we'll see her doing remote stuff because she was at the Orange County firm, unless she chooses, of course, to move to the New York firm. Brown Rudnick has firms all over the place, or locations all over the place, so she can move around wherever she wants to. She's a partner. She's still at Brown Rudnick. This is in addition. This is not a full-time gig. This is a legal analyst role. They'll call her in for a 10-minute interview on this or that, but now they have a direct line to be like, let's bring in Camille Vasquez. And look, let's be honest about what's going on with traditional media. They need people who are going to draw an audience. Camille Vasquez draws an audience. I went and looked at the Hollywood Reporter's tweet. Let's go look at this together, and you can not everything's flattering under this tweet, by the way, but let's go look at this Hollywood Reporter tweet together, and I'll show you why. Oh gosh, I have to scroll. It's been buried because they tweet so freaking often, but I wanted to show you how many impressions that tweet has just from the Hollywood Reporter story, so we begin to get an idea of the eyeballs that Camille Vasquez will bring. Now, will that continue on for a while? I think so. I'm interested to see her career grow, and I'm interested to see where she goes next. I'm interested after watching her do this trial. So this tweet has 471.4 impressions on it. The tweet about Avatar, 24,000. The tweet about entertainment giants team up on advertising currency initiative, announced plan to unify streaming viewership, great, 29,000 impressions. Prince Harry dominating the news cycle, talking about everything from his brother to his dick. I mean, literally 37,000 impressions. Lizzo talking about cancel culture, 50,000. Prince Harry some more, 30,000. So when you're looking at even the Hollywood Reporter, this jumps out as how much engagement this story about Camille Vasquez brought. Camille Vasquez is bringing in eyeballs, and that's what media wants. And if I'm Camille Vasquez, girl, get your bag, get it. Young attorney, growing her profile, get all of it. Get all of it. I have no shade. A lot of people in the comments had shade for her. I'm not I have no judgment there, but I can understand it, especially when you start looking at these numbers. I mean, when you're looking at all these other stories, this is about a Good Morning America interview with Harry, 22,000 impressions. The SAG Awards, 20,000. The Golden Globes, 24,000. You're just, the interest on the Hollywood Reporter, it's staggering how much, like Bumper in Berlin. I'm interested because I love Pitch Perfect. I'm the audience for this tweet. But again, the impressions are kind of consistent around 20,000, except for that one on Camille Vasquez. So, oh, and Disney employees returning to work. So that's what it is. No shade for her. Go get it, Camille. This is part of legal marketing and having attorneys that can be rainmakers, and that's part of being a partner. Part of being a partner is not just trying cases, it is bringing business into the firm. This positions her to bring business in for the firm, and I imagine everyone at the firm was thrilled for her, and I imagine Brown Rudnick is thrilled for themselves. Just thrilled for themselves with all of this. So let us continue on. We have more quick bits to get to. We're going to be wrapping up that poll. If you haven't voted, go vote, because we've got just a few more stories. Look, I thought we were done with this story too. Do y'all remember my coverage of the Nirvana Baby? I'm calling it the Nirvana Baby lawsuit. I don't normally get this cheeky, but this one from the beginning has annoyed the ever-loving fuck out of me. The man who was on the cover of the Nirvana album as a naked baby sued the members of Nirvana. The case got dismissed. Refiled the case. Case got dismissed again. And is now appealing to the Ninth Circuit with amicus briefs, the Friends of the Court briefs, and is appealing the court's dismissal of the Nirvana Baby lawsuit. So I will put a vote up for the members if we want to look at the appeal a little bit more in depth. I haven't seen it covered anywhere. I was going through my kind of end of the year closing out cases. And when I went into Pacer, I was like, a notice of appeal? There's a notice of appeal. There's a notice of appeal from the second dismissal. The judge made it so clear in the dismissal that you don't have a cause of action. Like, you don't have a cause of action. You're suing Courtney Love and the estate of Kurt Cobain, and you don't have a cause of action. So what I think I'm going to do is talk about the new Romeo and Juliet lawsuit vis-a-vis the Nirvana Baby lawsuit. Cool Springs, which is a location close to me, asks the important questions. How can Nirvana Baby afford this? Well, let me pull this up real quick. And this is going to be speculation. And yes, this is listed in my files as the Nirvana Baby lawsuit. Not all of them get a cheeky name. But there is a group that is doing the amicus brief here. When I have talked about Supreme Court cases and how things end up getting to the Supreme Court, a lot of times these cases are tested on certain laws or statutes or certain areas. This might have been a test case where a group reached out to this particular plaintiff and said, hey, we are interested in this lawsuit. Would you like to bring this lawsuit? And so it might be the group and not him. I don't know. But it is possible, and that is often how these suits work. So the amicus brief that was filed was from Child USA and Canadian Center for Child Protection, Inc. So this is the amicus. Could this be a group? Again, this is me thinking through the problem and speculating. Could it be that this group saw the album cover at some point and said, hey, this, with these new laws about statutes of limitations, the period of time you have to file a suit, could these new laws open a door where these sorts of things that we think are exploitative, where these things could come up for lawsuit and these laws could be clarified, and then go to the plaintiff and say, we're interested in this, would you? And the plaintiff being like, yeah, mount up and ride. It's possible. It's possible that there's a group behind this and it wasn't just this plaintiff on their own later saying, I think this is exploitative. I have to do a little bit more digging into that, but we now have an amicus brief and we now have a second lawsuit that is now from a movie, from the old Romeo and Juliet movie, suing over use of underage naked bodies in a public forum. So we will see. I think we just look at those two things together and have a conversation about statute of limitations and what have you. This case is not done. And I don't know if the amicus is what pushed him to get these things. Once they go up to the appeals court, you can at least get a more defined view of the law. So, Jenny Logan said, I want to see the lawsuit where he sued his parents. That lawsuit does not exist. Why doesn't the Nirvana Baby sue his parents? They're responsible for him being on the album cover. Yeah, he didn't. The Ninth Circuit, this is moronic. Look, that's where it's going. Didn't the statute of limitations recently change? Not recently, but we're still in the period where the change allows for a reach back into some of these lawsuits. Not the Leonardo DiCaprio Romeo and Juliet. No, just to be clear, no, not the Baz Luhrmann one that's fucking iconic because I'm a child of the 90s. And nothing is better than the Baz Luhrmann Romeo and Juliet with Leonardo DiCaprio and Claire Danes. I could talk about it forever. It's fucking iconic. Not that one. The 1960s something one. We'll talk. It's not in today's Quick Bits. But Emily, you brought it up. I'll bring it up again. I wanted to bring up that the Nirvana Baby lawsuit's not done because God, I thought it was done. Let's go ahead and end our poll and see where we're at. Nirvana Baby file. Yes. It's Nirvana Baby file. Let's go ahead and end our poll and see if we're going to talk about it. So the 60s one, there were two of them. They were both great. I'll take a look. So y'all are like, here, look, now we've got to just pull it up real quick to dispel rumors because I'm the worst. Movie. That was 1996, the Baz Luhrmann one, which, iconic. All right, lawsuit. I got this. A lot of you sent me this information that there was going to be a lawsuit over this. So let's just go to this real quick story by Deadline. This is a quick look. I have not read it. Romeo and Juliet director's son slams abuse lawsuit by actors. Let's see if we get a quick rundown. The actors, Pippo, I'm not going to pronounce, Zeffirelli, son of Romeo and Juliet director Franco Zeffirelli, is criticizing a lawsuit brought by the film's stars Olivia Hussey and Leonard Whiting. The actors are alleging sexual exploitation and child abuse in a lawsuit against Paramount Pictures over a famous nude scene in the 1968 film adaptation of William Shakespeare's play. Hussey and Whiting, now 71 and 72, earlier this week filed suit against Paramount. They alleged that the director violated their consent by filming them nude without their knowledge. Hussey and Whiting were 15 and 16 years old at the time. Zeffirelli died in 2019. We will get into that lawsuit if you guys want to get into that lawsuit. We just have not had a time yet. That's So Jessica. Anyone else had to watch this version of Romeo and Juliet in school? The one with the nudity of the teens. That tracks. 77% of you wanted to talk about the Chrisleys, so we will talk about that quick. I don't even remember if I've seen that. Wait, they're just now suing. Yes, they're just now suing. We will go through it. I don't recall if I've ever seen this. I might have to watch the movie and then go through this. So, yeah, we're going to have, the chat looks interested. The chat looks like they want to cover this. Miguelina, let's just put up a poll. We'll ask the 8,000 of you that are here now if we want to cover the Romeo and Juliet lawsuit, and I'll just throw it onto the docket to do a quick bits and pull it up, which means I'll have to watch it, which means I might not cover it till next week, but we'll still get to it. We have lots to do before this Murdaugh trial kicks off. So we need to go talk about our last quick bit, or we're never going to get through. Did I tell you that there's 105 new? I told you all the new things in the Girardi case, right? We have to zoom. We can't sidetrack. We cannot sidetrack. All right, let's go to our last. What's our last quick bits? Oh, the Chrisleys. We'll quick bit to the Chrisleys. Let's do that, and then at the end of quick bits, we'll end this poll and we'll just Girardi. Bravo, fucking bravo. Okay. If you follow reality TV, you might have stumbled across the Chrisleys and Chrisley Knows Best. Chrisley Knows Best, reality TV show. The Chrisleys went to trial. They lost a trial. They have motions for new trial and appeals pending. They asked for, and we have not covered this closely because we've had a lot of other things going on, and vacation. Everything happened over the Christmas. Emily. Great. They asked for a stay pending appeal. Hey, don't make us turn ourselves into prison while the appeal is pending. And I had talked about the fact that they asked for that stay pending appeal. The court ruled, and that ruling is in as of January 10th, which is today. So we're just going to go straight to the docket and take a look at what the court said. So here is the court's rule. We still have other court rulings to go over in this case. It's wild. Let's see if we can zoom just a little bit. Oh, there we go. I could see it zooming on my screen where I'm broadcasting to you, but it wasn't zooming on my screen where I was looking at it. United States District Court, Northern Court District of Georgia, U.S. versus Chrisley et al. Defendants Todd Chrisley, Julie Chrisley, they're the ones who are asking for that. Attorneys representing Peoples. Motions ruled on. Motion for bond pending appeal denied. Motion for miscellaneous relief denied. Motion for bond pending appeal denied. A motion for miscellaneous relief denied. These are the motions, 2 with regard to Todd, 2 with regard to Julie Chrisley. Court called to order also present during the hearing were FBI Special Agent Steve Ryzkoski and IRS Special Agent Brock Kinsler. Parties provided arguments. The court denied defendants' motion for bail pending appeal, which are found at docs 356 and 357. Additionally, the court denied as moot the Chrisleys' motion for prompt ruling on their bail motions, which is found at doc 365. Court denied defendants' oral motion to extend their surrender date by 21 days. Court adjourned. What this means is their surrender dates are coming up, I believe, next week. So they are going to have to surrender next week. They asked for an extra 21 days. Can you give us bond? Means let us stay out of custody while the appeal is going. No. Give us an additional 21 days. No. So literally the rubber has met the road in the Chrisley case, and they are going to be turning themselves in to federal custody in short time. So I believe their turn-in date is just next week. So that is what we are going to see. Because let's see if it says, where's there's the exhibits. I'm just looking to see if there's another reply brief as to Todd and Chrisley motion regarding bond pending appeal. Let's just pull this up real quick and see if the exact date's in here. I believe it is pretty quickly. So we're just going to look at the Chrisleys. The court was like, no, fucking no, none, no. Yes. Do go directly to jail. Do not collect $200. That's exactly what it was. All right. This is to Todd and Julie Chrisley, joint reply and support. So this is the last document that's filed. They would file a motion, the government opposition, and then their reply. This is the last one. We're looking at the last one. The government's response to the bail motions demonstrates further why this court should grant the motions. As a preliminary matter, many of the government's arguments rely on misstatements about the record. This is going to be fought out in appeal. And you know how I feel about some of the stuff that they've alleged. It's going to be very interesting to see. On the merits, its substantive argument failed to address and cannot distinguish the cases the defendants raise in support of their appeal. Without responding to the heart of the matter, the government instead attacks straw men and, in the end, resorts to relitigating determinations of community safety it previously lost. because there's nothing in the government's response to fairly meet the substantive weight of the defendant's motion for bail. Pending appeal, the court should grant the motions. So this goes through, again, their issues on appeal. They're going to argue that their issues on appeal are strong and that they have a possibility of succeeding. And so if they are likely to succeed, you can see that the government or the court might then say, okay, you have a reasonable likelihood of success. We won't put you in custody. Given the amount of time of custody they're facing, it was unlikely. But we've seen it in other cases like the, my brain is blanking on the hoax case where he had a very short comparative sentence and is out of custody pending appeal. It will come back to me in a minute. So we will, yes, Giglio violations are government discovery violations. So that is there. Can the Chrisleys get a sick note to avoid jail? No, they can't. They will just provide the medical treatment in custody. Harvey Weinstein tried that more than once. No, you just get in custody work. So this is them arguing essentially that there's no reason for them to go in while there are strong arguments on appeal. I do think they have some interesting arguments on appeal. I truly do. Jesse Smollett, yes, thank you. Chad is bae. That's exactly what I was thinking of. My brain has moved so far on. So let's see. Yeah, everyone else we've seen that we've covered that has asked to stay out of custody pending appeal has been denied except for Smollett. So this is, hey, they're not dangerous while they're out. And it's a fair argument. The crimes are old. So it's not as if they're worried about them relitigating or re-offending. So we will go through their appeals if you are interested on another day. We know essentially what their appeal arguments are going to be because we've seen these arguments brought up again and again and again, but the appeal has not been covered yet, or the appeal has not been filed yet that I've seen. So we have so much to talk about. Let's just move on. But the Chrisleys are going to be turning both of themselves in to custody next week. Let me see if I can find the date. I know that, and I'm looking for, I saw a comment zoom by and I was going to save it till later. I know that people had it and I saw it and the date escapes me, but the appeals will be coming and we can cover those. I saw a question about whether I'm going to be covering the court hearing on Thursday. We have, for the Idaho students, it's a status hearing. If it's televised, I will pull it up during our regular coffee and Cursey Words time. I believe it'll happen a little earlier, but I've seen those not streaming live. They've been on a delay. So I will wait and see if it airs on delay and then I will cover it. So it won't be live contemporaneous, but I will cover the video from that status hearing. It will probably be a very brief status hearing. The thing I will look for that status hearing on Thursday is whether a date is set for preliminary hearing. Let's see, Chrisley. Surrender date. These are the things I do when I prep the show before before I go live. If I know, let's see. Let's see. They were ordered to voluntarily surrender to authorities on January 15th. So 5 days from now. So that's when they will be surrendering, 5 days from now. So we'll see. Though there were conflicting reports that say January 17th and that Todd Chrisley is going to report in Pensacola, Florida by noon on January 17th. All right, let's just go to Pacer and see what it says and see if it's in there. We're just going to all look together real quick in Pacer. Let me pull it back up. It expired my page. Give me back my page, Pacer. Me looking to the far end of my research screens here. Where is it? Grr. All right, let's pull this up again and see if we have any. Not in there. We're just doing a research stream together today, friends. That's all right. We'll do a summary because now that we're adding the Quick Bits podcast, we will get a summary podcast at the end of the week. Todd's might be the 17th, but I wonder if Julie's is the 15th. So I'm just going to look real quick. Because then my brain will noodle at me and I want to confirm. Let's see, that's the redactive transcripts. That's when the financial arguments are due. Bond appeal, motions for Tuesday, January 10th. So the motions happened this morning and were denied. Let's see, denies the request for a later report date. But I don't see the memo. Anyway, so it's going to be one of those. Let's see if it has it. I will go look for it and confirm it when I do our quick bits roundup at the end of the week, because I am not seeing it in my shorthand. Let's see if it's in this minute entry real quick, because now I want to know. Because now I want to know. Let's see. Oh my God. I hate it when it's formatted like this. This is just, each court does it differently, but it makes it so much harder when it's not broken down into parts. Defendants are on bond, allowed to voluntarily surrender. All right, I'll go back through and dig through and find it, but it's going to be in that 15th, 17th range. So let's move on. Let's move on. Trisha G, question: why do famous people get to turn themselves in months after conviction, but normal people are taken into custody right away? Trisha G, the difference is not famous. The difference is state system versus federal system. This is tremendously common in the federal courts, but you don't hear about most federal cases unless they're being covered by the media because somebody's famous. But even in the state court difference, when you look at a defendant that's out of custody, where a case is covered, they often have time to turn themselves in. If a defendant is already in custody, which is much more rare in the federal system unless it is a violent crime, where the defendants are out of custody pending sentencing, then they have time to turn themselves in. Where the defendants are in custody, like a Josh Duggar, they get sentenced and sent off to prison right away. So it's not famous, it's in custody already versus out of custody. That has to deal with the types of crimes, whether you're in custody or out of custody. Yes, money can play a part in that. If you have the money to be out on $1 million bond or what have you, then you're more likely to not go in immediately. But it's my chair pissed me off. It's very, very common in the federal system, especially in nonviolent offenses, to see people turning themselves in later. So hopefully that answers the question. But in the US, we have federal and state, and it's more common in state court that people are in custody pending trial and not out than in federal court, et cetera, et cetera. So fame, I don't think, is the thing. Money is part of the thing, but also the types of offenses. So even with a violent offense with money, someone like Tory Lanez is out pending sentencing, even though he's been convicted of a shooting, so of a violent offense. So let us continue, because it's time. We're like 47 minutes in and we have a long way to go. Emily, you're talking fast today. What should we talk about first? We have the Girardi CFO in custody and some interesting information about the fraud within a fraud. We have the Chicago case. Well, not the Chicago case. We have the now moved racketeering case getting stayed with Jay Edelson. So CFO case with a transcript, Jay Edelson, and then all the new lawsuits. Those are the three things. So let's end what poll we had, and let's put up another. Michelina's like all the polls today. Let's put up another poll with what do we talk about first? The Jay Edelson case, new lawsuits, or the CFO fraud within a fraud? Those are the three things I want to know, and we will get into that as I note that I've talked about all of our quick bits. We're done with quick bits. Emily, 47 minutes is not quick. I know each individual bit was quick. It's time to talk about the Girardi cases. Do you want to cover the Romeo and Juliet lawsuits? 78% of you said yes. All right, we're adding it to the docket. Motion granted. Motion granted. It's formally been added. I feel like I need this to now be a squeaky, we should make gavel dog toys, but motion granted. So we have lots to do today with these cases. Let's see. Fraud within a fraud, the Chicago case being stayed. The Chicago case being stayed is probably the fastest. So I'm going to start with that because it's probably the fastest, and then I'll see what the poll says for the other two. How about that? I feel like that's a fair, let's go with the fastest one first and get it out of the way, because there's some information in there that I'm going to be referencing later. Look. This is the Jay Edelson one. When I pulled up Pacer yesterday to look at the new stuff in the Girardi case, I knew there were some new lawsuits with regard to Erika, and I knew that there were a few of them. And when I saw that there were 15, I was like, 15? So I got all my notes together. I got all the lawsuits. I started looking through them. And then I started going through the later dates. And I was like, oh my God, there's like 15 a day for days and days and days. And this is how I felt. Y'all know what's coming. My brain literally last night at like midnight, so maybe this morning, went like this. That was my brain. How are there 105? How? 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 How are there that many? Oh, Miguelina, because I'm going to do the Edelson one. The fraud within a fraud and the new lawsuits are the two that we're looking at in the poll. All right. Let us go. Let us look at what Jay Edelson had to say on Twitter first, and then we'll look at the reporting, because Jay Edelson had some tea here. Let's see. Oh, he's talking about the California bar. What did the California bar do today? Okay, did you guys hear my podcast with Jay Edelson when he talked about how the California bar responded to being alerted to all this fraud? Yo, it was shocking. All right, let's look at Jay Edelson's breakdown of yesterday's hearing. So, because the court sealed the Girardi filings, I cannot comment on those filings. I can speak about the things that we were told to us separately, and speak I will. So this is Jay Edelson making very clear that you know that Edelson is not talking about the things that were sealed in court, but talking about things that were told to Edelson separately from what was sealed in court. Let me put you into the position of where we're at. With the overall Girardi fraud, Jay Edelson was co-counsel on the Lion Air cases. Jay Edelson and his law firm at some point in all of this went, hey, what the fuck is happening here? Alerted the court, filed a lawsuit. This was the original, this is a lawsuit because of the defendant's greed. No, it didn't say that in this lawsuit. This lawsuit, called the Divorce a Sham, and talked about an alleged $20 million loan from the law firm to Erika Girardi's company. The writing of that lawsuit gripped the media, and they went, what? You think the divorce filing is a sham? What is happening? That's really interesting. So then Jay Edelson later filed notice that they were filing a case in Lion Air, saying we're filing a racketeering case. I covered that here too. Then Edelson PC filed the racketeering case in federal court in Northern California. Then that case was moved. So this is a hearing with regard to the federal racketeering civil case where Jay Edelson filed against Erika Girardi, lawyers in the firm, legal lenders, and said all of them were operating this law firm like a criminal organization, bringing money in, taking money out, defrauding clients, emailing them, running it like a Ponzi scheme, essentially. So that's the case that we're talking about now. It's a spinoff from the Lion Air case where Jay Edelson and Edelson PC are suing on behalf of clients, saying, yo, you were running this as a racketeering organization and all this money is gone because of it. All that coverage is on my Girardi playlist. There are so many cases in this. I need a chart with string. I'm going to make one at some point, like a digital version. So the filing, or the hearing and the filings with regard to yesterday, were sealed. What we know is that, well, let's get through it and then we'll get through the reporting on it. On January 5th, I spoke to, I didn't want to do that. I want to be here. And then I want to do this. Look, this is my favorite Twitter feature, that you can make it like a little like roll. I don't know if I don't know. I love this. All right. On January 5th, I spoke to Ryan Saba, Keith's lawyer. Keith is Keith Griffin, one of the former lawyers that's been named in tons of this stuff. You're going to see lawsuits against him later on today. I started by asking if he wanted to have a 408 conference an off-the-record conference or a normal conference. Ryan stated unequivocally it would be a 408 conference. Practice tip: lawyers often misunderstand Rule 408, which only deals with the admissibility of certain types of evidence. It is not a gag rule. So he's saying, look, this is a conference where I can talk about what we talked about. Saba told me that he understood from David Lira. Emily, don't fucking click things. From David Lira, Tom Girardi's son-in-law, married to Tom Girardi's daughter, Jacqueline. Did Jacqueline and David Lira just get sued as well in the bankruptcy? Yes. Saba told me, God, this feels like we're just like...
Oh my God. So I was talking to Keith Griffin's lawyer, and Keith Griffin's lawyer told me that he understood from David Lira that Lira would be indicted within the next 4 weeks. Yo.
So this is Keith Griffin's lawyer. Keith Griffin and David Lira were partners of Tom Girardi, David Lira being the son-in-law. Keith Griffin's lawyer is telling Jay Edelson that he understands from David Lira that David Lira is going to be indicted.
Oh my God, did you guys hear? She's actually dating him. I know. He was going to ask her to homecoming. I just heard it in the bathroom. I don't know if it's for real, but oh my God, you guys.
This is how this feels to me, and I'm fucking living for it. Like, I'm fucking living for this is what I was told, man. This is what, word on the street. Saba told me he understood from David, we need to have Jay Edelson back on the podcast, understood from David Lira that Lira would be indicted within the next 4 weeks or so. That's not a direct quote. This is my summary. Saba did not have any direct knowledge of the truth of this statement, but indicated Lira would file a motion to stay the case based on the forthcoming criminal indictment. The case got stayed yesterday. All of the things are filed under seal, but I think this indicates to us that what's being filed under seal is there is a criminal indictment coming, not just the criminal indictment of the CFO fraud within a fraud, but potentially criminal indictments for partners in this law firm. Y'all, we're at the tip. We're at the tip of the spear in the biggest legal fraud we have ever seen. If they arrest lawyers from this firm, not just the CFO, lawyers from this firm, it will be unlike anything we have ever seen, where a law firm is potentially running like a criminal organization and taken down under racketeering and wire fraud laws. It's fucking wild. It's wild. And it went on for so long. And we're seeing 105 new lawsuits in the bankruptcy to claw back money. Y'all, the way I'm going to be watching the news to see if people get arrested, the way I'm going to be watching the news, well, watching Law 360 because they break news really fast and I appreciate them and their lawyers. Saba indicated Lira would file a motion. A motion was filed under seal to stay the case based on the forthcoming criminal indictment. No other people were implicated on that phone call. However, I have been told by others, I think that's by others, non-insiders, that Lira and as many as 4 others at Girardi Keese would also be indicted in the coming weeks. Question, which case is worse, Girardi or Murdaugh? I'm going to come back to that at Q&A because we're going to have to go through all of this. Nobody's dead in the Girardi cases as far as we know at. So murder is more serious, but the amount of money we're talking about in Girardi is much higher. So I don't know how we apportion worse. We're going to come back to that because I want to think through it and talk about it a little bit more. However, I have been told by others, I'm assuming this is by others, not my others, that as many as 4 others at GK will also be indicted in the coming weeks. The CFO's been indicted. So there is no lack of clarity. All of the above is hearsay. I think that's fair. This is this is what we're hearing. The only thing that supports it is that Saba told us that David would file a motion to stay the next day and indeed did so, based again on a vague reference to criminal developments, and this was mostly sealed. No one should take any of this as some sort of implicit signal that the sealed filings corroborate any of this because he's not allowed to. I'm only reporting what I was told by people who didn't have firsthand knowledge. So he's saying word on the street is that criminal indictments are coming. Let's take a look at what Law 360 had to say about it from Brandon Lowry, who's been following the Girardi part of this case super closely. Girardi Keese suit halted as criminal investigation looms. Y'all. Oh my God. A Chicago federal judge paused Edelson PC's fraud and theft lawsuit against Girardi Keese attorneys Monday at the request of one of the defendants who had asked for a stay because of unspecified developments in a federal criminal investigation. What we learned from the indictment of the CFO is that the CFO knew this was coming based on the conversations being had and the people being talked to about this. And I believe there were target letters that went out. So the CFO knew that they were a target of a federal investigation. So if these attorneys are the target of a federal investigation, if Erika Girardi is the target of a federal investigation, at this point, we know that they know. We know that they know that this is coming, which is wild. Y'all, are we going to see the feds and I'm not saying Erika's going to get wrapped up in all of this. I don't know. This could just be the lawyers at the firm. But are we going to see all of this go down while Housewives cameras are rolling? Is it going to be like a Salt Lake City part two? Like we had Salt Lake City, we had the feds roll up at Beauty Lab and Laser to arrest Jen Shah and she wasn't there. And then they went and found her and raided her house and everything else. Is this going to be lawyers at Girardi Keese getting arrested and indicted while cameras are rolling for Real Housewives of Beverly Hills? Because it's possible. We just saw that there have been cast shakeups. We just saw Lisa Rinna leave the cast and others announce that they weren't coming back. Filming could happen while this is happening. And if not, they could start filming on the tail of this news dropping the way I want to know. The delay comes as federal authorities in Los Angeles and Chicago ramp up their investigations into claims that the firm ran a Ponzi-like scheme. Go back to my coverage in 2020 and look at what I call this law firm. Because I wasn't wrong. Emily, how long are you going to victory lap on calling this a Ponzi scheme for fucking ever? All. Because it was running like a Ponzi scheme with clients' money. They unveiled their first criminal charge in the scandal against Girardi Keese's former CFO. In November, the FBI and IRS agents have recently interviewed several of the firm's former clients, focusing on its disbarred founder, Tom Girardi, and other attorneys. Y'all, if they arrest Tom Girardi, I'm gonna send out all of the signals and be like, law nerds, let's ride. We need to process this information together. If they go and arrest Tom Girardi, I will be stunned. Woo! Y'all. Focusing on its disbarred founder, Tom Girardi. However, the precise developments that led to Monday's stay were not publicly revealed. David Lira, Girardi's son-in-law, requested the stay in a sealed motion last week. Most of Monday's hearing before the judge was held out of public view. The stay affects the Chicago-based Edelson PC's suit against Girardi Keese, stemming from the firm's joint representation of several Indonesian families whose relatives died in the 2018 Lion Air crash. The Edelson firm claims Girardi Keese stole millions from their mutual clients. Edelson sued Girardi Keese in December 2020, revealing the once celebrated Los Angeles plaintiffs firm had stolen millions from its clients. Many more clients have since come forward saying they were also ripped off. The firm is believed to owe hundreds of millions. I think the number's up to like 400. Hundreds of millions of dollars to former clients, co-counsel, lenders, and vendors. And there's 105 new lawsuits about where that money went that we're covering next. Since the firm's downfall, Girardi has been diagnosed with Alzheimer's disease, placed into a conservatorship, that's true, and disbarred. The attorney, famed for his role in obtaining a $333 million pollution settlement that inspired the 2000s film Erin Brockovich, has not been publicly charged with a crime. Yet. Federal prosecutors in Los Angeles said Girardi Keese's former CFO, Chris Kamen, embezzled more than $10 million from the firm in a quote-unquote side fraud. It's your side piece to your main fraud, just for when you need a little extra action. Paying for real estate, travel, and female companionship, and doling out money to sham vendors. Lira, who now works at Ingleston, Lipscomb, and Lack, they're going to be lacking a lawyer if he gets fucking indicted, filed a motion to stay the case under seal January 5th in an accompanying document. This law firm has to be like, maybe now is the time we just don't anymore. He said the motion should be kept sealed because it relates to developments in pending federal investigations. So Lira knows. Lira knows what's coming. Related to issues pending before this court, he said the information should be kept confidential because no charges have been filed. Once charges are filed, can we just unseal it? Who's making the motion? Jay Edelson probably will. Let's unseal it once the indictments happen. Like if indictments happen, when indictments happen, let's go ahead and unseal all this because inquiring minds would like to talk about it on the internet. After the hearing on Monday, Edelson PC founder Jay Edelson praised federal prosecutors for their apparent progress. Quote, Girardi Keese was a criminal operation that was disguised as a law firm, he said, adding that he and his firm really look forward to them unraveling this huge crime spree. Oh yeah, Edelson PC is ready for everyone to be indicted. That much is clear. All right, let's go ahead and finish the poll and take a beat and see what we're covering next. Question: if Girardi does get charged, won't his lawyers say he's unfit to stand trial because of Alzheimer's? Yes, they will. They absolutely will. They will say he can't be held responsible. It doesn't mean they won't charge him. Please re-add Law Nerds Unite to the intro. Sophie S., I've taken that under advisement. We can do that. I think we can do that. We need a cursey word counter that counts down to when we can drop them. Also coming from Ohio, nursing on the couch with my 11-month-old. Oh, baby. I watched a lot of YouTube when my kids were nursing. Jan said, did you hear that you got a shout out on UK TV show this morning? I didn't. A commentator said that she watched your channel for the Johnny Depp Amber Heard trial. Jan, I didn't. But if anybody saw that, tag me in it or share it with me to my email. I would love to know. I didn't know that. Thanks, everyone who watches. I appreciate it. Thank you for sharing that with me. Watching while getting a memo. You know what? I did mine not that long ago, towards the end of last year. Holly said I would not be able to sleep ever again. Fair enough. WAP sound should be the fan opening smack sound. Oh, I should just do it every time I have to say we are professionals. Because we did get the wonderful WAP fan from a lovely Law Nerd. These have a name on them. These have a name of the type of fans. They are Daft Boy fans. Thank you to the Law Nerd who sent me these. They're great. That should be the one. We're coming for Peter Mon. We're not. We love Peter Mon. He does this better than I do. We are professionals, folks. We will try, because sometimes we are professionals. That's the wrong one. Sometimes it's just that. Finally made it to a live. Been watching since Depp v. She Who Must Not Be Named, and wanted to. She got sued by Johnny Depp too. No, I'm teasing. Some of the Law Nerds will get that joke. Some of the ones will be like, "Wait, there's two She Who Shall Not Be Named." Yes. Wanted to thank you for sharing your expertise in such a soothing and fun manner. Well, you're welcome. I love being here with y'all. Did you look at the order sealing the affidavit warrant of Brian Kohlberger? It's sealed, but the language is interesting. I did not look at the sealing order for the affidavit because we have the affidavit. If this is something new, I will go look. I'm going to keep hold of this. I looked at the gag order. I looked at the affidavit, but I haven't looked at a sealing order. Guthrie's husband, Michael Feldman, consulted for Vasquez and other members of Depp's legal team. It's good to know. Maybe it's maybe why NBC got chosen. Can you look at the LOL Dolls lawsuit against TI? I will add it to the docket. I don't know when I will get to it. Why does Camille need to do this if she's a partner at a huge law firm? I'm a little disappointed, if I'm honest. Sophie, I saw a lot of those comments too. And I hope that all of my explanation made sense. I think for this is a lot of marketing. This is a lot of marketing. And also it's one of those things as a lawyer that's fun to get to do. Like it's fun to get to talk about cases. It's fun to get to talk about cases and share your expertise. Kraken Creative Studio Storytelling Artistry. I snorted it. She is totally dating her. I mean, there we go. Challenge, take a sip of water every time Emily gets irritated at bad law writing or excited at good law writing. I mean, you'll stay hydrated. No one would know who Nirvana Baby was unless he didn't make a big deal out of it. That's true. Just saying, how could he be harmed if he's the one calling attention? It's a fair question. Oh, we're going to get to this at the end. Because let's see what our poll said. New Girardi lawsuits, 41%, fraud within a fraud, 58%. Y'all are here for the criminal tea today. All right, criminals it is. Criminals it is. Let's do that first. There's a transcript. Let's go take a look at the fraud within a fraud. There's so much going on in that case. And then we will get back to all the new lawsuits. Don't worry. Those are financial tea. This is criminal tea. Both are not cold brewed. Both are pretty hot. So let's go to the Law 360 article first, and then I'm going to pull up, where is my Girardi file is ridiculous. It's got like subfiles on subfiles at this point. That file is named Girardi fraud. There's a chart. I need to update my chart. This is my old chart of lawsuits against Tom Girardi. It needs a substantial update. My chart is out of date. The problem is shit keeps happening and then I don't have time to sit down and work on my chart. It's like needing to have time to study and not having time to study. That's where we are at. All right, CFO criminal case. I think I'm going to go to the last, me talking it through. We're going to go to the last opposition first. All right, let's look at what happened. We're going to kind of work backwards in time. Ex-Girardi Keese CFO stays jailed as judge cites flight risk. So, coming from Law 360, a California federal judge on Monday ordered Girardi Keese's former CFO, Christopher Kamen, to remain jailed on a wire fraud charge, finding him a flight risk and rejecting as, quote, not nearly adequate, love judges, a proposed bail package that included his new $2.4 million Bahamas home. I wonder if he lived down the street from Sam Bankman-Fried. I have questions. His new $2.4 million Bahamas home and properties belonging to a friend and relatives. I think he thought he was going to yeet himself to the Bahamas and be done. We know the Bahamas are going to extradite. They extradited Sam Bankman-Fried. They would have extradited him, but he came back to visit and they nabbed him. U.S. District Judge Dale S. Fisher heard arguments from prosecutor and defense counsel from Skadden Arps. By the way, this is like $1,000 an hour law firm. I have questions. Before a packed courtroom gallery filled with Kamen's relatives and supporters. That's not what I was expecting. Packed courtroom gallery filled with his relatives and supporters. Presumption of innocence, ultimately ruling that the former CFO shouldn't be freed for now, pending trial on a single wire fraud count. For now. Because I imagine if more indictments are coming, there could be more indictments coming here. Kamen, 49, had worked at Girardi Keese for 20 years before the firm's highly publicized downfall. Was alleged to have spearheaded a conspiracy scheme that bilked more than $10 million from the embattled law firm's accounts, the majority of which contained client funds. He's been in custody since his arrest in Baltimore in early November. The judge said the proposed bond package to secure his release and guarantee future court appearances were insufficient to assure Kamen would not flee the country. According to Kamen's proposed bail packages, the properties offered as collateral for his release included his newly purchased $2.4 million home in the Bahamas, his aunt and uncle's home, and his close friend's residence. Kamen also offered to relinquish his passport. It looks like that's been done, to subject to electronic monitoring and to remain at his aunt and uncle's home in Southern California should he be released. Oh, that makes more sense why there were so many people in the courtroom. These are all the people in the courtroom to say, hey, he's not a flight risk. He'll be here. They want the Josh Duggar treatment here. Josh Duggar got to stay out of custody pending trial. He was remaining at somebody's house. He was not at his own home. He was on electronic monitoring and he had all these conditions. He stayed there. So this defendant is saying, hey, can I just get that? Can I just get, I'll stay at my aunt and uncle's, and this is the collateral, and I'll be on electronic monitoring. I'll pay for the electronic monitoring. Please let me stay out of custody. And the court was like, negative. The judge took issue with the fact that Kamen, who was unemployed, had 4 mobile phones at the time of his arrest. Look, most people don't have 4. 4's a lot. Unemployed at the time of his arrest and had 4 mobile phones, had liquidated all of his assets and transferred them out of the country. He was trying to run. He just did it really badly. He liquidated all of his assets and transferred them out of the country, noting, quote, "It appears there's evidence he's using shell companies to put his assets out of reach or harder to reach." Okay. I'm not at all persuaded by the surrender of the passport. Electronic monitoring is no insurance the defendant won't flee. Yeah, ask Fat Leonard. Fat Leonard was on electronic surveillance and still fled and cost the government quite a lot of money to go track him down. The judge added that Cayman's recently purchased home in the Bahamas won't serve as much assurance either. Since it's in the Bahamas, I'm not sure what it would cost to go after that. So that's not particularly helpful. Yeah, we don't want to have to fight the Bahamian government over this fucking property right now. Like, that's not what we're doing. Furthermore, even if the court was to accept his relative's home and the childhood friend's property for Cayman's bond, Cayman could reimburse either party for any harms if he were to decide it was better to flee than spend 15 years in prison. So he could flee to the Bahamas and then give them the money out of the money that he has hidden offshore, is what the court is worried about. I do appreciate the offer of his aunt and uncle, but as I said, Cayman has more than enough to replace their residence if he decided to flee. So if the government took his house, they could be reimbursed by him. The judge said, adding the court would be more susceptible to a bond package that included a combination of other conditions. So the judge is like, I'm not doing this. I'm not foreclosing the possibility of an adequate package, but as I said, that'll be after some substantial evidentiary hearings, and I am certainly open to considering a proposed combination of conditions. That's something other than what's presented, which is not nearly adequate. Not nearly adequate is strong. Monday's detention hearing stems from a motion Cayman's counsel filed December 30th, arguing he should be released pending trial, considering his lack of criminal history and the nonviolent offense which he is charged. Prosecutors pushed back, urging in court in a January 3rd opposition brief to keep Cayman in custody, arguing he liquidated his assets before leaving the Bahamas, wired millions of dollars abroad using shell companies, and lied to the Maryland district judge about his residency upon arrest. Lying to the judge when you're arrested isn't going to go well for you. Cayman is accused of embezzling more than $8 million from the firm through a series of fabricated invoices, fraudulent transfers, and cash kickbacks from the Girardi Keese accounts to a host of shell entities and bank accounts controlled by a group of co-schemers that he directed. Cayman used the firm's money to pay real estate, personal travel, and lavish gifts, a $20,000 monthly allowance for a woman he purportedly met on an escort website, federal authorities alleged. Yeah, and like a $100,000 purse. Prosecutors allege in court papers Cayman had specific knowledge of the unfettered access to the Girardi Keese finances and oversaw the firm's accounting. Cayman was a signatory on several firm accounts, prepared checks on the firm's behalf, including checks drawn from the firm's client trust accounts. You're not supposed to be drawing checks on those other than to give them to the fucking clients. And was the primary point of contact for the payment of the firm's expenses. Cayman was aware of the litigation, bankruptcy proceedings, and government probes surrounding Girardi Keese since 2020, but cooperated with the bankruptcy trustee and voluntarily gave up $120,000 to the trustee for a payment previously made by the firm for his car, stated the defense's motion on December 30th. In 2021, Cayman invoked his Fifth Amendment right to avoid self-incrimination when the bankruptcy trustee tried to get him to testify about the firm's finances. Millions of illicit proceeds from the scheme remain outstanding, prosecutors said, adding they believed the money he transferred abroad and used to buy his Bahamian home belonged to the firm's victims and former clients. The government also said it wants to hear a determination of the source of the money and the extent Cayman proffers cash or other personal assets. You can't put up assets stolen to secure your bond. They're not your assets. They're subject to forfeiture. On Monday, it was argued that Cayman was only transferring assets and selling his Southern California property in order to start anew in the Bahamas, slamming the government's nefarious interpretation. That's what the government's going to do, though, when an indictment is pending, and we know that an indictment was pending, we're going to go to the bail hearing. But what we know from things that have already been filed in court is that the woman who he had an arrangement with, he asked to go to the Bahamas with him. She had already been contacted by prosecutors and interviewed. She told him that they were investigating him. He knew the investigations were coming. So all of this was done after investigations were coming. So being like, y'all are being too picky. it's, it's just hilarious to me. But this is what defense attorneys do, right? He was just trying to start a new life in the Bahamas with his BFF, SBF. I'm completely making that up. Slamming the government's nefarious interpretation as picking apart every aspect of Cayman's move to suggest he was planning to flee. He was in the Bahamas with a brand new house that grants him citizenship. And he had liquidated all of his assets. What do you think he was doing? It seems like he's preparing to flee. I don't know if that's a nefarious interpretation. I think that's a reasonable probability. But all right, defense attorney's gonna defense attorney. Cayman bought a home and applied for residency in the Bahamas in his own name, told his family and friends where he was going, and was living with his sister in Baltimore as he was traveling to and from the country. None of it was a secret, he argued. Look, he told people where he was going. This wasn't a secret. The issues around the law firm have been percolating for 2 years. That's a long time, the defense told the judge. During these 2 years, Cayman's prior and current counsel reached out to the Department of Justice to let them know we're here, happy to talk when you're ready to talk to us, and they never engaged. After a certain point in time, a person should have a chance to decide to relocate and start fresh, not sit back and wait when the government hasn't engaged with them and suggests they'll be indicted. The government had every opportunity to do it. The government doesn't get to sit on their hands for 2 years and have everybody freeze their lives until they're good and ready to do something. Have you met the feds? If they want him to not move, they should have picked up their phone and called me. Okay. The prosecution, however, contended Cayman's actions were consistent with an individual who wants to escape, as he is on notice of at least one criminal investigation. Oh, that specific language, at least one, and a plethora of civil litigation, some of which he's named as a defendant and had actively avoided service. So he's trying to not get served a lawsuit. Nor has Cayman ever been told he was not the target of the government's investigation, prosecutors argued. On the day he was arrested, myself and my colleague reached out to defense asking, do you have any idea where your client is? The prosecution argued. He said, no. This concept that his client's location is open and widely known is absolutely false. The prosecution revealed to the court that Cayman attempted to buy the property in the Bahamas in the name of an associate, maintaining that he was, quote, personally at the interview of a co-schemer who provided the information to the government. So the prosecution was talking to a co-schemer, not a co-defendant yet, because they haven't been indicted yet. But this also leads me to believe more indictments are coming. Who provided that information? Oh, well, he tried to put it in somebody else's name. What did the Bahamian government say? Bro, no. The co-schemer, however, is an unwitting participant, not the target of the government's investigation. Oh, this might be the woman he asked to move there with him. During the interviews, the unnamed co-schemer claimed Cayman told her, yeah, I'm guessing that's who it is, because that's where they got a lot of this information on Cayman from. During the interviews, the unnamed co-schemer claimed Cayman told her he had feds. If you really don't want us to put things together, start using they, them for literally everything. Just keep it very neutral and we won't tie it together. If you want it to be an unnamed co-schemer, if you want us to tie it together, fine. But if you want it to remain unnamed, just say, the unnamed co-schemer claimed Cayman told them. It's not hard. I don't think they wanted it. I think they wanted it to be clear. During the interviews, the unnamed co-schemer claimed Cayman told her he had the authority to pay her directly with Girardi Keese funds. Girardi Keese, once celebrated plaintiff's firm, founded by the notorious Thomas V. Girardi, was revealed in December 2020 to have stolen millions from its clients in a Ponzi-like scheme. Yup. Many more clients have since come forward saying that they had also been swindled. Yup. Do you guys want to look at the transcript from the detention hearing? I love it. Thank you to the government for including it. But here's the government's brief, which is funny. Look, here's my note to you if you are using Google Docs. We will also be using Google Docs on this channel. We always do. But if you do not clear your notes, I can still see them. I can see them. I can see them. I appreciate that you're cut and pasting, and I appreciate that that's the only one. And I think it's the only one. Let's see if there's any other notes running down here. But clear the notes. It's 120 pages. Just that's all. If you're going to be putting things in Google Docs, clear your notes because they stay in the, oh, there's more notes. They stay in the metadata. All right, we're going to learn as we go along because I was zooming too fast, but there are more notes. Look, it's fine that they're just from incorporated documents, but still, I don't need to see them because what if, this terrifies me as an attorney. What if you had a note in there that was needed? This has come up in more than a few cases where we have seen Google Notes attached to the documents. The documents have been uploaded to the court system, be it LA or be it the federal system. And we have seen the notes end up on here. Now I have to figure out how to get rid of those without just closing them out. Don't show me the notes. I need a better PDF reader. WAP. But it's just too funny having these notes in here, and it throws off the alignment of the document that I'm trying to talk about. Anyway, this terrifies me. When you take something and upload it to the government website, all of that metadata is still there. When I download it from the housing form on Pacer, that those notes were still there. I think I got them turned off. Lordy. All right, so this is the second. There were two. There was a first set of bond motions and a second set of bond motions. This is the answer in the second set of bond motions because the government kept adding more info. So instead of going all of it, we're just going to the end because why not? All right, table of contents, points and authorities, relevant facts and procedural history. That's the information, like that's the tea that we really want. Argument, defendant liquidated assets in this district and surreptitiously fled the Bahamas. Defendant wired millions abroad using shell companies. Millions of illicit proceeds from defendant's scheme remain outstanding, which means they don't have their hands on it yet. Defendant's significant sentencing exposure in this case and others. And others. Sentencing exposure in this case and others. There are no other indictments yet, but the government put in and others in here. So y'all, the tea leaves are there. There's more coming. It's like a bad moon. It's rising. The bad moon's on the rise. I hope that's the right lyric to that song. Anyway. It could be wrong. It could be blood moon. I don't know. All right. Defendant's significant sentencing exposure in this case and others provides incentive to flee, which he has already acted on. There is a whole transcript. We're going to get to it, but we're going to look at how the government lays out all of this information because this is really the first time we've had a chance to look at the CFO's indictment. So, well, not the indictment. The indictment's still sealed, but the facts underlying the sealed indictment. So what did the CFO know? And what is this fraud within a fraud? I always said there's a bad moon on the right. Yeah, I think a lot of people did. I think it's on the rise. Yes, it's CCNR, but I think a bad moon was the lyric I was worried about. All right, perfect. Thanks all. Chat is back. On November 5th, 2022, upon his arrival into the United States from the Bahamas, defendant was immediately arrested in Baltimore, Maryland on a criminal complaint alleging one count of wire fraud. Great, because the thing is still sealed and we haven't been able to pull it up, so at least we know more clearly what it is, based on a multi-million-dollar fraud scheme that he orchestrated as the CFO of the now defunct law firm Girardi Keese GK, not JK, GK. JK and select individuals working there, including disgraced attorney. It's over and over. It's going to be disgraced, embattled, nefarious, notorious, all the words, disgraced attorney Thomas V. Girardi and defendant are being investigated for a long-running and wide-ranging scheme to defraud clients by misappropriating nearly $100 million in settlement money from JK clients. I imagine every lawyer that worked in this firm has a lawyer trying to figure out who's getting indicted, or they know. Because oh my, oh hell yes, we're in a lyric type of a mood today, but it doesn't take much for Jay Edelson, if he's been paying attention to this more than I have, because I'm sure he has, because it involves a case that he's working on, and we cover more than just Bravo here, though we have enough to just cover this. But the feds are making all of the "there's more coming," like this is their preview of like to be continued. They are not making any secret that there are, which means the targets know that they're being targeted. They are making no secret of the fact that they are targeting more people in criminal investigation, and that this is the beginning for this defendant, and more is coming. Against that backdrop, the complaint accuses defendant of also carrying out a separate fraud scheme wherein he skimmed well over $10 million from Girardi Keese and funneled that money to bank accounts and properties for his own personal benefit. We're going to get more to personal benefit later. In 2021, soon after the news of GK's financial troubles broke amid a slew of civil lawsuits, including the one from Edelson PC, and the firm's ultimate bankruptcy, defendant began liquidating his assets. Oh, the timing. God, the amount of documents these prosecutors are going to get to go through and trace the money from bank account to bank account is going to be, it's just going to be delightful. Did I like fraud cases? Yes. Am I a nosy bitch? Yes. Did I love a case where we have a defendant in custody and the defendant's girlfriend is still using the defendant's bank account to pay for things like Match.com while he's in jail? Yes. I'm nosy. And then when you find something like that, you're like, huh, that's interesting, because she's on the jail calls like, I love you, baby. Why are you spending your money on Match.com then, boo? You looking for your next? Well, he's in custody. He did not love it when the detective said, hey, did you forget to cancel your Match.com subscription? Because it's still getting paid for. The next jail call was a lot. Remember, if the detectives are telling you information, they're then listening to the conversations you're having after you've received that information. Is this a real story? Yes, this is a story from a case that I prosecuted. It is a real story. The defendant also threatened me on those jail calls, but in the way that only a white-collar criminal defendant can. I'm going to find your social security number. Wait, did this really happen? Oh, yes. Yes. For those of you new, you're welcome to put a 1 in the chat. I was a criminal prosecutor, so the stories I tell are either from my cases or my own. I will always tell you if I'm imagining a circumstance where, I will generally say I'm imagining a circumstance where. Oh, the detective was like, hold my beer. Well, we thought that the girlfriend, and we were right, we thought that the girlfriend was holding on to devices that we wanted to search and wouldn't give up the devices, and we needed more information to get a search warrant, to get probable cause to get the devices. And them fighting over it, they started talking about the devices in the jail call, which then gave us the information we needed to get a search warrant for the devices that the girlfriend had. So, yeah. Look, man, detectives don't just tell you things. They're better than I am. Detectives don't just tell you things for no reason. They will tell you things for a reason. Because with jail calls, we know who you're talking to. If somebody is talking to multiple people, sometimes it will be like, well, did you know? So-and-so's also, like a detective would ask, hey, girlfriend, whoever, who's so-and-so? The detective isn't asking a question that they don't know. They're not asking a question that they don't know. Who's so-and-so? Because they've already heard the jail calls and they know who so-and-so is. And then you will normally get a, what do you mean they're talking to so-and-so? And then the jail calls will have a wealth of information, because you generally get the people who are on the outside saying, I can't believe I'm doing this and this and this and this and that for you. Well, you're in there and you're still talking to so-and-so and so-and-so. We could talk about this forever, but we're not going to, because we have 105 lawsuits to still get to. But if people don't think jail calls are listened to, your jail calls are listened to. All of them are listened to. They are listened to. You're not as clever as you think you are when you're talking about things in custody. Even if you try to use code words, it is not that clever. It's not like nobody's ever done it before. All right. I don't want to teach people to crime better. We're going to keep going. In 2021, soon after the news of the financial troubles, this defendant began liquidating their assets. Again, these are all allegations. Presumption of innocence. This is just an indictment. We're at the beginning stage of the prosecution. Danny, we will do a whole conversation about jail calls another time and the things that I have learned through jail calls. Also, just a PSA, or maybe not. I mean, if you really don't like the prosecutor in your case, jail calls can't be sorted very well. So like prosecutors going into a jail call don't know if you're talking to someone about where you hid a weapon or where you hid narcotics or crime proceeds or a witness that you're trying to find or trying to get somebody's information. They don't know if that's what's in your jail call or if it's you having phone sex. They don't know going in until they're in. And then they're like, holy fuck, I'm in this. This is in there. But you also don't know if that is started to get me, the prosecutor listening to it, to go, I'm out. Fast forward. And then you talk about the important shit in the middle of it. So no, those get listened to. Even when you're having phone sex, even if the person you're having phone sex with, you're asking to make certain bodily functions so that you can hear them. And then I have to come into court. Is this an example from my life? Yes. And then I have to come into court and sit there and look at you and look at the person in the audience who I've heard you two have phone sex. And I know what you're into and I know the bodily functions you're asking them to do. And I have to sit here and look you all in your face. In court. My face does not have a poker face. And I'm like, hey, defense counsel, got some jail calls for you. You might want to remind your client that we hear everything on the jail calls. And there are things I don't need to know. Thanks. Thanks so much. There are so many people who make money writing novels about this. I should be one of those people, except I would turn them into like weird fanfic. Wait, if it is a dirty phone call, are you required to listen to the whole thing? Well, some people will try to bury information in the middle there because they think we'll skip over it. That's the problem. And you never know. Somebody has to listen to it. Sometimes you can just ask your detectives to do it. You can be like, detective, I got into can you just, I can't do this. It just depends. It just depends. All righty. Somebody asked, I don't want to ask people to crime better. If you speak a foreign language, you'll still get found out. Yes, especially in Los Angeles, there is a wealth of interpreters and a wealth of district attorneys who speak a wide variety of languages, not to mention that, things like AI interpretation will get you far enough that you can kind of figure out if there's information you need and then to send it out for interpretation that can be used. So yes. So anyway, is that when the judge was like, Miss Baker, your face? No, that was it. That's a completely different story. We will get to my face story. We will tell it to everyone another day. New job called Jailhouse Call Screener. I mean, a lot of the times DAs do that themselves. Other agencies might do it differently, but in LA, a lot of the DAs and detectives do it themselves because people aren't familiar with the case, don't necessarily know what they're listening for. And sometimes you don't even know what you're listening for until it comes up more than once and you're like, oh, this is code. Let me go back. You need to know. All right. This defendant started liquidating assets, including through the sale of several multi-million-dollar properties. Thereafter, defendant began wiring millions of dollars to foreign accounts located in the Bahamas and elsewhere. That's the first time we're hearing about stuff out of the Bahamas. We're diversifying the countries where we're moving money offshore to. Defendant told a former associate that he wanted to leave the country, change his name, and hide. I imagine they have that on tape. Your Honor, we believe that the defendant would like to change their name, leave the country, and hide based on the fact that they fucking said that. That's why we'd like to not bail them out, please. Consistent with that plan, defendant purchased a $2.4 million home in the Bahamas with stolen funds and even attempted to put the property in the name of an associate to obfuscate. Can I still pronounce that word? No. Obfuscate? To hide his ownership. Then on September 22nd, 2022, defendant failed to board a return flight back to the United States from the Bahamas, and he remained there for nearly 2 months until he booked a last-minute flight to Maryland. Oh, I imagine he was becoming paranoid that they were going to grab him. On November 5th, 2022, defendant was arrested upon his arrival in Baltimore, so they were tracking him 2 months prior in September when he didn't board his flight back, it seems. After his initial appearance and detention hearing in the District of Maryland, defendant was ordered detained due to his significant risk of flight. Defendant attempts to mitigate that risk now before this court by characterizing his relocation to a foreign country as a, quote, fresh start that was, quote, widely known and fully transparent. However, defendant ignores that at the time he fled, he was enmeshed in litigation related to his role in the broader GK theft of client funds and personally named in at least one federal lawsuit, which he had successfully avoided service. Defendant was able to avoid service by actively keeping his location unknown. So it wasn't transparent if he was avoiding service on all the civil lawsuits. Chelsea, fresh start from what, sir? A fraud, perhaps? Including from his own defense attorneys who did not know where he was until informed by the government of his arrest. Counsel, do you know where your client is? No, we got him in Maryland. So he's in custody there. Now you know. The more you know. Defendant also proffers his $2.4 million Bahamian property as a 250,000 unsecured appearance bond. However, as established herein, defendant's Bahamian property was purchased in part with tainted funds linked to the stolen money from Girardi Keese. The government's like, we haven't gotten to forfeiting that shit yet, but we're going to get the house. You can't put the house up as collateral when we're going to take it anyway. It's not collateral that you went back. That's getting forfeited. If you are convicted, yoink. The government takes your shit. Forfeiture equals the government takes your shit. So you can't put it up for bond to secure your appearance when you don't give a fuck because we're taking it anyway. Say goodbye. Say goodbye. Courtney and more. And more. And more. And to the extent the defendant proffers cash or other personal assets, the government would request a nebia hearing to determine, let me make this bigger, the source of said funds. You can't give stolen funds to the court and say, here's my money. You have to prove that that's clean money, which coming from Girardi Keese is going to be hard to prove any of it's clean money. Uh-oh. There's ice in there that I don't want to chew in the microphone because that's worse. That's just too loud. Now it's just rolling around in my mouth. Apologies, y'all. All right. Much of defendant's assets are directly linked to stolen Girardi Keese funds. Aside from the defendant's personal assets, he proffers two sureties that can post approximately $1 million combined, secured by real property. However, as discussed below, defendant's ill-gotten gains from his various schemes far exceed this proposal by more than tenfold. So he has tens of millions. So it doesn't matter. It just doesn't matter. And most importantly, all of these stolen proceeds have yet to be recovered due to the defendant's international transfer of funds. It's still being hidden, and we don't want to give it to, he could just repay the people that lose their properties if he runs. That's what they're worried about. In the months leading up to his arrest, including just the day before, the defendant drained his domestic accounts by wiring millions into foreign accounts, including accounts in the Bahamas and even in Hungary. To date, the government has not been able to seize any of the millions stolen. Yikes. Yikes. Accordingly, a $1 million bond, when setting aside defendant's own tainted assets, pales in comparisons to how much the defendant has stolen and still retains, and thus cannot assure the appearance. Facts and procedural history. The complaint charges defendant with only one count of wire fraud for his involvement in the scheme to steal money from his employer, GK. As GK's CFO, defendant had specific knowledge of the finances and supervised the accounting department, was a signatory on bank accounts, prepared checks on behalf of GK, including checks drawn from client trust accounts. No, sir. What you can't do. Did he write up did he write it up for the earrings to M&M Jewelers, the scandal earrings? Did he draw up that check and was like, yeah, it's a great idea to use a client trust account to buy $750,000 earrings? Were you part of that, accountant? Seems like you, I'll just continue. And was the principal point of contact for payment of GK's expenses. We're going to dig into those expenses more later. Defendant carried out his scheme, among other ways, through a series of falsified invoices, fraudulent transfers, cash kickbacks from GK accounts to a series of entities and bank accounts controlled by a group of co-schemers that defendant directed. Defendant, I want to know who the co-schemers are so badly. Defendant also improperly used GK funds to pay for millions in personal expenditures, such as home renovations to defendant's multiple properties, extensive international travel, and to pay for female companionship. Indeed, 2 properties in this district that defendant sold in 2021 and 2022 to facilitate his flight to the Bahamas were financed and or renovated directly with stolen funds from the GK accounts. The estimated amount of misappropriated GK funds due to the defendant's side scheme is estimated at well over 10 million. Well over 10 million. The thing is, when you don't have property in the US, it's very, very hard for the government to seize it. It's harder to seize it when it's out of the country. Defendants know this. I'm not telling you how to crime better. Defendants know this. And if the houses were still in California, the government could just seize the California properties. It's harder to get it in foreign bank accounts. It's why people do this. It's why money laundering gets charged in cases. And I wonder if in the future we will see money laundering charges in this case. But this moving it out offshore to try to make sure the government can't grab it is not uncommon. And a struggle for the government always. Based on the wire fraud charge, defendant faces a maximum sentence of 20 years imprisonment, and his guidelines alone estimate a term of imprisonment between 135 and 168 months imprisonment. Footnote 1. This guideline estimate is only for defendant's side fraud, as alleged in the complaint. More charges are coming. Defendant's potential exposure from the broader scheme perpetrated by Girardi and others, including defendant, is expected to be greater than the instant allegations, as the losses in the broader scheme are anticipated to near 100 million. Let me read that again. This guidelines estimate is only for defendant's side fraud alleged in this complaint. Defendant's potential exposure from the broader scheme perpetrated by Girardi and others, including defendant, is expected to be greater than the instant allegations, as the losses in the broader scheme are anticipated to near $100 million. Your professors in law school teach you to read the footnotes where the good shit is. This is what this footnote says to me. This footnote says to me, Your Honor, we have this defendant on this one charge, but there's like a much bigger indictment with like a lot more people coming, but we didn't have it. I imagine that they probably arrested him on this then because he was back in the country and they needed to make sure he didn't go back to the Bahamas. So they were like, okay, we could get the side fraud. The indictment's not ready for everybody. This is the government saying in a footnote that the potential exposure on the broader scheme is coming, and it's over $100 million. That's what they're saying is coming. There is $100 million indictment that is fucking coming for this defendant and others. So, Your Honor, this is just like holding time. Like the 30-year max is just like a cute little bit to get us started. It's an appetizer, if you will. But the $100 million fraud indictment is coming. Between everything we're seeing, between Jay Edelson's tweet and between everything the government's talking about and between Lira making that motion, Tom's son-in-law son-in-law making that motion to pause the proceedings and then the judge doing it, this shit is happening. This is coming. When it's coming is unknown, but this seems and feels imminent. Wow. Footnotes, man. Footnotes. It's a coming. Yikes. Or also, yay. I mean, we'll finally see some criminal accountability in here. I mean, That's what that says to me. All right, footnote 1 coming through with the T. I might have to make a quick bit on that quicker. At his initial appearance on the complaint, defendant was ordered, because this is new information to me. Defendant was ordered detained by Judge Maddox. Case, defendant was ordered detained based on a finding by a preponderance of the evidence. There is a serious risk that the defendant will not appear. I think everything gives us that impression. Judge Maddox listed additional grounds for the detention order based on, quote, reasons stated on the record at the hearing, including defendant's dishonesty regarding where he was currently residing. Exhibit 1, detention hearing transcript. One significant factor in my detention here is that your claim to pretrial services to be living with your sister who lives in Maryland over the past few months. But it turns out that your sister didn't know where you lived. Damn. Me saying I'm staying at a friend's house when really I'm not actually at a friend's house. I'm living with my sister, and sister is like, I don't know where he is. The defense attorney is out here like, everyone knew he was getting a fresh start in the Bahamas. He was finding himself, getting a new start, needed to get away from all the stress in LA, had to find a fresh start in the Bahamas. He's not living with the sister. He's everyone knows, it's transparent. He told everyone he was moving. He tells pretrial services, I'm living with my sister. Sister tells pretrial services, I don't know where he lives. This is the power of grabbing him before he can see the sister and grabbing him at the airport. Sister's like, she doesn't go here. We don't know where he lives. Upon his arrival in the Central District of California, defendant made his initial appearance before the Honorable Judge Karen L. Stevenson. Judge Karen might be the shorthand, though. The Honorable Judge Karen on December 19th, 2022, and was ordered temporarily detained pending a detention hearing on December 28th. We now know how that went. At that hearing, Judge Stevenson determined the jurisdiction was proper in the district and referred defendant's bail motion to this court. So the bail motion got put over. Everybody's like, what I did in high school. Yep. Everybody's like, sounds like teenage me. Right. Teenage you's not lying to the judge. You're lying to your parents. Normal part of being a teenager. Well, the fact that my parents couldn't track me on a cell phone when I was a teen is probably a good thing for me. Argument. Do we need the legal argument? Detention is appropriate where defendant's a danger to the community or flight risk. They're establishing he's a flight risk. They're not arguing he's a danger to the community. All right, we're going to have to wait. That's too icy to drink on a live stream. All right. Defendant liquidated assets in this district and surreptitiously fled to the Bahamas. Defendant's desire to sever community ties also strongly supports that he is a flight risk. Beginning in at least August 2021, defendant began liquidating his assets. So this is after everything crumbles, including through the sale of his residences in Palos Verdes and Encino, California. In fact, in his rush to flee, defendant even sold one of these properties at a loss when factoring the millions of dollars he poured into the property's renovations. Defendant's fire sale of his assets was prompted by news of GK's years-long theft of client funds going public. Over the next year, defendant was implicated in several lawsuits across the country related to GK's theft, and even personally named in at least one of the lawsuits where he successfully evaded service of process until he was arrested in the matter. See Edelson PC versus Lira et al. That's the Edelson case. And then he's in custody, and they're like, no, we know where you are. We can serve you. Ex parte application requesting extension of time to serve defendant and outlining diligent efforts to find defendant, including through retention of professional process servers. While defendant claims, you can only run for so long. While defendant claims that his relocation was open and transparent, he cannot dispute even his own counsel law firms, even that his own counsel's law firm, Skadden Arps, had no idea where the defendant was located. Indeed, Skadden was subpoenaed in October 2022 to provide defendant's Palos Verdes address long after he sold the property. Indeed, Skadden was subpoenaed in October 2020 and then provided defendant's Palos Verdes address long after he sold the property. Where is your client? He's in Palos Verdes. See? Like, the government's like, that house has been sold. What? This is the address we have in our files. That's not helpful. Notably, at the time of his arrest, defendant's current counsel was also completely unaware the defendant had relocated outside the country to the Bahamas. I thought it was transparent. I thought it was transparent. Accordingly, defendant's claims that his move was widely known, including through his proffered family declarations, should be rejected. Defendant attempts to excuse his flight from prosecution by claiming cooperation in civil proceedings, and his counsel's communication with the Department of Justice at large must also be rejected. As an initial matter, defendants claimed quote-unquote cooperation with the bankruptcy trustee is demonstrably false. Despite the trustee's attempt to designate defendant as the person most knowledgeable for Girardi Keese, defendant vigorously opposed the trustee's motion, and when he lost, he proceeded to invoke his Fifth Amendment right against self-incrimination to virtually every question asked of him except his name. The bankruptcy trustee said the person who knows the most about this bankrupt law firm is this defendant. And he's like, I'll cooperate, but I just won't answer your question because it will incriminate me, because it would. Like, this is, if you're going to plead the Fifth, this is the appropriate time to plead the Fifth. But what you can't do is turn around and say, I've cooperated. No, you haven't cooperated with shit. You don't have to cooperate with shit. You have an absolute right to not cooperate with shit. But cooperating and not saying shit are not the same thing. Those words cannot be used synonymously. Cooperating and remaining silent are not synonymous. They're not. What? This fucking case. Oh my God, this case. In fact, defendant even declined to verify his current address when asked. I plead the Fifth. Where I live is a matter of security to myself. I don't want to be served with lawsuits, and I refuse to tell you where I live. That doesn't feel like he's cooperating. Yes, he's pledging information. He is pledged to cooperate. He is pledged to cooperate. I cooperate by remaining silent. He's pledging cooperation. Moreover, defendant attempts to conflate his counsel's communications with the government attorney in Chicago with the government's criminal investigation in this district. At no time did the U.S. Attorney's Office, they don't all talk to each other like you would think they would. At no time did the United States Attorney's Office for the Central District of California ever communicate to defendant or his counsel that defendant was not a target. In fact, defendant even concedes that no law enforcement officials anywhere, including in Chicago, ever told him he was not a target, because he was always a target. Notably, defendant's own prior counsel states that despite his repeated inquiry, Chicago officials never confirmed that defendant was not a target. Yet, despite any such confirmation, defendant still chose to relocate to a foreign country. Because he's obviously a target. That's why he pled the Fifth. He knew he was a target. Defendant's flight was even more suspect. It was sus. Given his specific knowledge and notice of his criminal exposure. To wit, defendant's knowledge and notice of his criminal exposure are evidenced by his multiple declarations submitted in civil proceedings and his repeated assertions against his right against self-incrimination. We know it's coming. See this declaration and the declaration of Christopher Kamen. Quote, I am aware that the United States Attorney's Office for the Northern District of Illinois is conducting a criminal investigation of Girardi Keese where I was employed. I will assert my rights under the Fifth Amendment and decline to make a statement or answer any questions. Further, if called as a witness in pending contempt proceedings, I would invoke my constitutional rights to remain silent. And that's the contempt proceedings that I've covered and talked about that took place in Chicago. Thus, defendants attempt to use silence from the U.S. Attorney's Office or the Northern District of Illinois regarding ongoing separate criminal investigations to justify his surreptitious relocation to a foreign country should be rejected. Oh, that's a little sassy for the feds. I appreciate the snappiness. I like it. I like it. I like the use of surreptitious. Cheers. Defendant wired millions. Lisa said, did he learn that trick from AH? No, it seems to be consistent when people don't want to be forthcoming. Defendant wired millions. My husband just sneezed so loudly, it scared me. Defendant wired millions abroad using shell companies, relocated to the Bahamas, and lied to the Maryland court when asked about his residency after liquidating his assets in this district being California. Defendant began wiring millions offshore, including the Bahamas, where he told a co-schemer he wanted to relocate. Defendant's transfers to of these funds were all conducted through shell corporations such as Star Emerald LLC and Birch Leasing Company LLC, although defendant nothing named Lavish Lifestyle LLC. Although defendant notes that he is listed as the contact or caller for these transactions on international wire details obtained by the government, that does not change the fact that these shell companies were created and used to add another layer of separation between defendant and his tainted assets. In addition to the defendant's liquidation of assets, he also told an associate that he wanted to get out of the country, change his name, and hide. Consistent with the plan, he purchased a $2.4 million property in the Bahamas, attempted to put the property in the name of an associate to hide his ownership. Notably, in neither the Maryland Pretrial Services report nor the PSR prepared in this district does defendant ever mention his property in the Bahamas. In fact, defendant told the Maryland Pretrial Services officer that he lived with his sister in Maryland, despite his sister stating that she was unaware where defendant physically lived. Oh, man. Such discrepant residential information in part formed the basis of the Maryland recommendation of detention. Defendant attempts to it's not going to go better for you if you are found to be lying. Defendant attempts to explain this misrepresentation as a technical misunderstanding that he used his sister's house for a mailing address. No. I pledged to live there. No. No. Living somewhere means living somewhere. It doesn't mean, well, I've used the address in the US because I've fled the Bahamas. Those are different things. However, the Maryland Pretrial Service officer and the judge were not convinced. Quote, you claimed to pretrial services to be living with your sister who lives in Maryland, but it turns out that your sister didn't know where you lived. At best, defendant admitted material information from the Maryland court and staff to avoid detention. However, according to one of the defendant's co-schemers, defendant told her to communicate with him using Signal, a messaging application that uses end-to-end encryption to keep anyone from seeing your messages. Footnote 3, of course they did. Defendant's attempt to innocently explain his use of Signal to mitigate costly data fees is not credible given the millions he has spent in the past several years, including the hundreds of thousands of dollars spent on monthly allowances for his female companionship, the hundreds of thousands spent on exotic sports cars, and his extravagant shopping sprees. Not lavish? Extravagant today? Including one outing to Rodeo Drive where he spent over $75,000 at one shoe store alone. Government attorneys. What shoe store? But what? Can you please give us the details that we want to know? I know that's the foremost in your mind while you're trying to, prosecute a massive law firm that's running as a Ponzi scheme, but we're curious. Indeed, when defendant was arrested on November 5th, he had nearly half a dozen digital devices, including 4 mobile phones. This is consistent with witness accounts that defendant was suspicious of law enforcement investigation and indicates a level of concern over being tracked or apprehended. Although defendant attempts to normalize his possession of multiple mobile phones, it is uncommon, unless you are a YouTube tech reviewer. Unless you are a YouTube tech reviewer, then carrying like 4 or 5 different devices at once is totally normal. But in this circumstance, I think the context clues let us know that maybe he's not reviewing the latest and greatest iPhone. Although defendant attempts to normalize his possession of multiple mobile phones, it is uncommon, especially for an individual who's been unemployed for nearly 2 years. Millions of illicit proceeds from defendant's scheme remain outstanding. They're offshore. Ooh, details of how they moved. Yes, the government can trace your fucking money. They can trace everything. Furthermore, defendant's access to substantial sums of money is especially troubling due to his foreign ties. Indeed, as alleged in the complaint, defendant, which is still sealed, defendant has been liquidating his U.S.-based assets and wiring significant funds to the Bahamas and elsewhere. For example, as noted above, defendant abruptly sold his residences in the U.S. for, approximately $5.5 million collectively, and wired $2.2 million to the Bahamas, at least $700 to a foreign account in Hungary. This money traceable to defendant's schemes remains outstanding in whole part due to defendant's continuous transfers of these funds, including up until the day before he was arrested. Defendant now proffers his $2.4 million Bahamian property in support of his release. However, this property was directly purchased with the proceeds of the sale of his properties from this district, and as alleged herein and in the criminal complaint, which at least we learn more about it because it's sealed, investigators have already traced significant portions of the stolen GK money to those properties, thus the use of tainted funds, tainted love, All right, sorry. Thus, the use of tainted funds to purchase the Bahamian property must disqualify it as a source of bond. Yikes, yikes, yikes. The treaty process, even for countries with whom the United States government has good relationships, is difficult, lengthy, and unpredictable given that it relies on a foreign sovereign to take action. Footnote 4. Defendant also argues that his relocation to the Bahamas, a foreign country with an extradition treaty with the U.S., somehow mitigates his flight risk. However, this argument is unavailing. Setting aside the delays and complications with foreign governments noted above and observed by the Maryland magistrate judge, defendant's relocation to the Bahamas, quote, could have served as a launch pad to further flight. It would have been easier to flee from the Bahamas than to fly from the United States, given the circumstances of the case. So it's a jumping off point to further fleeing to other countries, which we saw with Fat Leonard. Moreover, the defendant's proffer from other assets, including a $250,000 unsecured appearance bond, raise additional issues. Defendant's years-long theft of millions from GK permeates all of his current assets. Indeed, that is the sole explanation for how defendant, quote unquote, a bookkeeper at GK with an approximate salary of $350,000, has lived such an extravagant lifestyle. Lavish and extravagant. We're going to have to treat those synonymously. We have to treat lavish and extravagant synonymously in these cases. Some prosecutors use lavish, some use extravagant, but generally they don't use them interchangeably. Is tainted funds a legal description? Yes, it is. Tainted is used widely in law, especially when we're talking about things like evidence. You get the fruit of the poisonous tree doctrine where you talk about tainted evidence. But yes, if you steal money and then buy a house, the house is tainted because the money was stolen and used to buy the house, even though the house is not the stolen funds. Actually, it's tainted by that. So yes, tainted funds is and the use of the word tainted is quite common. And I don't know if it's I don't know what else you would use for that, because otherwise you're just calling it dirty, I guess, the dirty money. But tainted is generally the acceptable legal term for funds that came from criminal proceeds. So yes, tainted is the preferred term. Let's see. So lavish lifestyle, extravagant lifestyle, which is included, among other things, multi-million-dollar properties, exotic sports cars, travel on private jets. Oh, we're going to talk about private jets in a minute. And now representation by no less than 6 attorneys. Six attorneys aren't going to help. They all just want the T2. These are 6 attorneys whose partners are like, do you have anything and more information on Erika Girardi? 6 attorneys is so many. It's excessive. 6 attorneys from Skadden. Good God. Including 3. Oh, only 3 from Skadden. Good. It's a very large, expensive law firm. At a minimum, the government would request a nebia hearing before any of defendant's personal assets are proffered. Well, the court denied. So a review of defendant and co-schemers' bank reveal at least 5 checks for amounts between $10,000 and $15,000, totaling at least $65,000 from defendant's co-schemers' accounts to Mr. Koo's company, Hammer and Wood. So they're talking about the homes here, I imagine, unless Hammer and Wood is a euphemism for something else. Oh, moreover, defendant's scheme involving sending fraudulent funds to family and friends, including his longest friend, Nelson Koo, whom he now proffers as a surety. This is my friend. My friend will make sure that I return to court. Well, your friend's company, Hammer and Wood, was getting a whole bunch of money from your scheme. I don't know if that's who we can deal with. 6 attorneys. Who does she think she is? Lisa Barlow? Yes. Nothing says I'm innocent like 6 attorneys. The Bravo editors are like, attorney number 1, attorney number 2, attorney number 3. But like, seriously, attorney number 4. I can assure you that I am none of those 6 attorneys. And they're glad for it. I would be like, I need to know more. All right. So you can't proffer your longest friend as a surety when your longest friend is also benefiting from your crime spree, is what the government is saying. While defendant claims that Mr. Koo's involvement in defendant's scheme is innocent and in exchange for legitimate construction work, the fact remains that Mr. Koo's company received at least $65,000 of illicit funds traceable directly to Girardi Keese funds that defendant and his co-schemers stole. Such involvement, even if innocent on Mr. Koo's part, must disqualify him as a surety. Defendant's significant sentence exposure in this case and others. This is what we want to know. Let's learn more about the and others. And others. Defendant's sentencing exposure in the underlying charge is significant, which is a factor that can legally be considered. Here, if defendant is convicted of the wire fraud charge in the complaint, he will be subject to a significant sentencing exposure because of the loss amounts generated in the fraud scheme. Yeah, over 10 bumps up. Under like 5 million is, I think there's a tier list of how much money you took to bump up your base for your charges. So over 10 million is going to bump up your base charge. Under the applicable sentencing guidelines, defendant total offense level would be approximately 33. Hey, I think Jen Shah's was 32. So we're right in the range of Jen Shah, which, assuming a criminal history category 1, would result in a range of 135 to 168 months. The federal sentencing guidelines have all these different numbers, and they take like your base range is this number. Jen's was like 32 or 33 with her base range. So you take the base amount of crime and it's a certain number, and then you add on how much was stolen if it's a theft crime, and you add on previous criminal history, you add on multiple victims, and you keep bumping up the base level crime, and then you go across the chart and it's like base crime, base number is this, that correlates to number of months is this. And that's how you can take all these different factors of the defendant into consideration. Prior criminal record or not, how much was stolen or not, how many victims or not, were the victims vulnerable or not. And in sentencing memos, we often go through the facts, but we don't always go through the argument over, no, this shouldn't be a 3-point gain, this should only be a 1-point gain. And we don't always go through them arguing over those numbers. And we didn't in the Jen Shah case. They did that more in the Chrisleys case. We didn't in the Jen Shah case because they fixed 33 as the appropriate offense level. Hopefully that's a good quick explanation to understand federal sentencing guidelines. We talk a lot about federal cases. Maybe we'll go over it a little bit more. I should pull up the I should save a version of the sentencing guidelines chart so we can just pull it up when we talk about this stuff for visual. Moreover, this guidelines range does not include defendant's involvement in the larger fraud scheme. But wait, there's more, which has losses of nearly 100 million. That's going to bump that base number up past 33. Defendant's sentencing exposure is significant and yet another factor weighing in favor of detention. Moreover, defendant is certainly entitled to a presumption of innocence. This court must consider the weight of the evidence against defendant when considering detention. And the overwhelming evidence which has been produced to the defense already demonstrates the defendant fraudulently transferred millions of dollars from Girardi Keese's accounts to accounts he owned and or controlled during a multi-year period. Defendant was involved in and is on notice of Girardi Keese attorneys misappropriating nearly $100 million of client settlement funds for unauthorized purposes. Defendant's affidavit stating that he intends to invoke his fifth. Indeed, as noted above, prior to his relocation, defendant was enmeshed in litigation and even evaded service. So, conclusion, remand, defendant. Let's go through some of this hearing, even though I think they probably pointed out most of it. Good morning, Mr. Kamen. You may all be seated. Mr. Kamen, you're here for your detention hearing. It will be decided today whether you will be ordered detained pending trial on this criminal case. It's pending in the Central District of California. The date of this hearing is November 2nd. This is in Baltimore. So this is the time of the arrest. I remember because I was in Palm Springs when this went down. I was like, so much is happening. I expect that various aspects of this case will be discussed, probably to include some of the evidence against you. And I expect that the lawyers may say things like drawing conclusions based on the evidence that they will be discussing. But I want you to rest assured today is not the day of your trial. the court, going through the court things. Today is not a day where you'll be judged innocent or guilty of the charges, but one of the things that I need to consider today is the weight of the evidence against you. So the evidence will be discussed, but until the date of your trial, you will still be entitled to the presumption of innocence. Do you understand? Defendant, yes. And so then they get into arguing that defendant is a flight risk. Let's see. This is the government arguing, Your Honor has had an opportunity to read the complaint that came to us from California, but briefly, if I may, the allegations in this case surround the fact that defendant was the CFO for a large LA law firm called Girardi Keese. And when I say large law firm, for someone like me who has been a prosecutor my whole life, when I hear a firm that makes hundreds of millions of dollars a year, that is unfathomable to me, because apparently that's the type of law firm we're dealing with. Nothing says I chose wrong when I got out of law school. Like, Your Honor, I'm just a government lawyer. Apparently, if you go a different route, there are firms that make hundreds of millions of dollars a year. Who knew? I'm just a Fed. Oh my God. I feel nothing more true than that statement. It's just unfathomable to me that, I just get a salary and it's on the government pay scale of public employees. And I just, come in and try to stop people from criming. But apparently if you do this differently, there's more money involved. Well, legitimate firms also make that much money, but that is just something else. That's really funny. I love that. This is what you love about court. Apparently this happens, Your Honor. Apparently hundreds of millions. In this case, the law firm was bringing in that type of money until it was forced into involuntary bankruptcy in 2020. Defendant, by the very nature of being CFO, had precise and very specific information. In this case, and what is charged in the complaint is the allegations of what I will call a sort of side fraud, which he is directly responsible under these allegations for approximately $10 million or more of loss from Girardi Keese, which I will refer to as GK. The firm is also subject of a larger theft scheme that is being investigated, with other targets or persons being charged. And the loss on that is about $100 million of a schedule. And that loss is from clients who paid the firm for their services. And that money was being funneled out and stolen in part by this defendant and others. It's also from plaintiff's awards, but this is more precise language. This is why I love having the transcripts. This is more precise language that is being investigated, with other targets or persons being charged. Imminent. Fraud charges imminent. Indictments imminent. Others are being charged with a loss of $100 million. How many years are we going to be talking about Girardi Keese? Because once we start the criminal process, some of these might go to trial. The wildness that all of this could go to trial in federal court where it's not streamed, I might just be like, y'all, I'll stream at night. I'm going to court. I will go sit on the hard ass benches in court every single day. I want to see what happens. If these things go to trial, we will find a way to be there, law nerds. We will have coverage in that court. But oh my. Persons being charged. $100 million. It is very, I have a whole playlist if you want to get up to speed. The prosecutor in Maryland's like, this isn't my case. I don't watch Housewives. I just don't care. It is known that the defendant was responsible for cutting the checks from this firm. He was in charge of distributing settlements or money to the clients. He had an intimate knowledge of the attorneys and the clients in the firm, who was getting paid, who wasn't. He was very aware that these clients were therefore not getting paid in the way that they were supposed to under their arrangement with this law firm. This is not a Robin Hood type of theft. This is not a drug addiction type of fueled theft. This is purely greed and a lavish lifestyle. Whoop, there it is. Thank you to the federal prosecutor in Maryland. There's our lavish lifestyle. My colleagues in California told me this is some shit. No, that's not what it says. My colleagues in California told me that the base level offense for this case for Your Honor's consideration is 33, and that its guidelines again are 135 to 168. The judge, that is the range. That's the range right now. But again, obviously, that's just approximate for today. The weight of the evidence against the defendant is vast. And to my left, let me introduce you to the FBI and the IRS that are here. Tell you that the co-schemers were interviewed as part of the case already, and they have informed law enforcement that the defendant would specifically give them thousands of dollars in checks for refurnishing his own personal home, or for them to deposit into their account, and then they would give cash back to him. That's money laundering. There's the money laundering. There's the money laundering. There's the money laundering. As simple as that. They would give him checks to deposit into their accounts, and then he would get the cash from them. And these companies were actually in the books that Girardi Keese maintained and listed as other vendors. We're going to get to the vendor list in a minute. He set up these shell agreements with these co-schemers, giving them money, taking, and I will use the colloquial term, kickbacks from them in order to hide the theft that he was committing. He used checks from the company, as I sort of indicated, to do multi-thousands dollar repairs on his own personal property. He's responsible for cooking the books, if I can use that term. It's a very prosecutor things to say. Paying checks to Bravo, which is one of the construction companies. What are the chances that there's a construction company named Bravo involved in this case too? Bravo's like, it's not us. It's not us. It's not the network. Bravo's like, leave us the fuck out of it. We've got kickbacks. We've got money laundering. We've got Bravo, fucking Bravo. He also had a female that he was paying $20,000 a month, sort of, I will use the term retainer. She was his companion, and apparently they met on an escort service type of website. He would lavish her with gifts, including purses that are valued at $120,000, including trips to Africa on safari and things of that nature. I mean, no shade to her. Do we think she knew where the money was coming from? No. He was... The defendant makes about $350,000 from the last time he filed taxes, and his lifestyle that we are hearing about is clearly someone who is living well outside of that and is being furnished by the money he was stealing from the law firm. The female witness that I was speaking of is the sort of person who provided the most information about the flight risk that we'll get into in a moment. So they just said it in the detention hearing that his companion is who told the feds everything. Good. Get a lawyer. Talk to the feds. Generally, my advice is don't talk to the police, but if you are not the target, the feds operate different. Get your own lawyer, take their advice. This is not legal advice, but we saw what Stuart Smith did, and he was involved. This is someone who's probably not involved and just benefited. Oh my. She was someone who was also receiving and benefiting from the money the defendant was stealing from the law firm. As to the history and characteristics of him and the dangerousness, I will submit on that. Like, he's not dangerous in the sense that he's going to hurt people, but you never know what people will do when backed into the corner. In the Murdaugh case that I'm going to be covering live starting at the end of the month when it goes to trial, or when it's scheduled to go to trial, the prosecution says part of their theory of why they are alleging Alec Murdaugh murdered his own son and wife is to cover the fraud scheme. So while he has no criminal history of being violent, you kind of never know what people are going to do. Alicia, I'm using girlfriend and companion synonymously. So, wow. He had 5 properties in California. Not in California. Oh, 5 properties total. I apologize. It's hard to know when we're dealing with. So the government attorney is like, I work for the government. I have a property. There's a 30-year mortgage on it. The government attorney's like, oh, I'm sorry. Not 5 properties in California, just 5 properties in total. My bad, trying to keep up with how many fucking homes you have. It's hard to know when he is not willing to discuss what his actual direct finances are. And we know that he is under the shadow of all the money that's going in and out of his bank account. Court, can I ask about the evidence that supports these additional properties in California? I understood that he admitted he did own property in California that recently sold. Yes. The court, so what evidence of other properties? The prosecutor, he sold those properties as well, Your Honor. They are listed in other parts of California, and he has since liquidated and sold them. The court, but what is the evidence that it is him. I mean, what is the nature of the records that supports it? The prosecutor, so it's my understanding from my colleagues in California that they did searches on the sales and determined he was the person who bought it. The court thinks. And we have mortgage payments, and they have mortgage payments as well, Your Honor. So there's an agent here that's also giving information whose name is redacted out of the record that was present and in court. Because the prosecutor, you've got to understand, the prosecutor in Maryland is not the prosecutor that's investigated this case. This is just the person in court arguing the detention motion. This is the person who's gotten a phone call from their colleague being, so I've got this guy coming in. Let me give you the quick rundown, and let me give you a rundown of the evidence. So they're doing a very fast, like, keep this guy in custody and get him to California. This is very important. If he doesn't stay in custody, he's in the wind. Keep him in custody and get him to California. But also, this is not the prosecutor who knows all the things. So this is why you see a redacted agent also being like, and mortgage payments, and then the prosecutor going, and mortgage payments. The court, thank you. So those are the factors they're addressing today, and then they give more of the information that we've seen. But I think our key takeaway from this, and we need to get to the other lawsuits, but our key takeaway from this for me is that there are other cases imminent, and that the feds believe that the overall Girardi Keese criminal fraud scheme is a $100 million plus fraud scheme. Speaking of 100, do you like it? Look, it's like we segue naturally. Speaking of 100, there are 105 additional lawsuits in the bankruptcy that we have to move on to now that we've stopped talking about aside fraud and companionship and money. This defendant at this point has stayed in custody. This individual will probably keep staying in custody, and there will probably be additional indictments. We will see them shortly, and they will just be like, we're all going to wake up to the news one day that a whole bunch of Girardi Keese attorneys have been indicted. That's my guess. That is my guess, because they said more. But let's go to the 105 lawsuits so I can explain what the fuck these are about, because Lord, when I thought there were only 15, I was on Twitter, I'm like, there are 15 more lawsuits. And people are like, 15 more lawsuits. And at that point, I was like, I think it's Erika, her ex-husband. What I forgot last night in my 15 new lawsuits, look at this, no, 105, was that Erika's son and ex-husband have the same name. One's a senior, one's a junior. And they didn't clarify it. So then I was like, oh, wait, the son's a junior. I need to go digging through this and see if they mean the son or the ex-husband. Because I'm like, it doesn't make sense that it's the ex-husband, but maybe it's the son. So the bankruptcy trustee, and this is like a law and lumber, and I can't wait. We need to have a conversation about this. The bankruptcy trustee in the Girardi Keese law firm is trying to claw back any monies that were paid. Fraudulent transfers, preferential transfers, and they can reach back 7 years and look at money that was going out of the law firm that's either giving a preference to one creditor over another, or that is not a proper transfer. And they are trying to grab it all back in and say, hey, not only do you have money that you shouldn't have from the law firm, give it back, but also if you have a claim, you don't get it. So the bankruptcy trustee is trying to limit the creditors to the proper creditors, saying, if you got a preferential transfer or a fraudulent transfer, you shouldn't get paid. Pardon me, I should have done our music. Because coughing on stream is so attractive. Sorry, y'all. All right. Let's reduce our bumper a little bit, and we'll just leave it in the background. So, we absolutely need to get Law and Lumber on a stream, because this is wild, and we'll have to talk about it. I'll have to give Rob the catch up and be like, Rob, you're never going to believe what's happening, because he's going through all the stuff going on with SBF and FTX. That bankruptcy is exploding the way this one does, but 105 new lawsuits is absolutely mind-boggling. But this is where the money went. Let's actually look at where this money went. So let me pull up my notes. I'm going to tell you who some of these lenders are, and we're going to look at a few of these. Here's a note. Most of these are copy-paste. So helpfully, we're looking at the ones that I'm really curious about the amount of money that's being spent on, and then we'll get to Q&A. But we're going to go through one lawsuit with all the allegations. And then what the bankruptcy trustee is going to do is plunk in the information regarding certain creditors. But we're going to go look, because I spent all the damn time last night writing them down. So we're going to go do it. The amount, I need like a whole day to just update my notes on this case, because I've been delayed in doing it because things happen so quickly, and then I cover it and then I move on, and then I need to get back to doing it. But we have so much more to cover in this Girardi Keese bankruptcy. So some of the creditors that are being sued for things like fraudulent transfers, like, hey, the law firm shouldn't have paid you that, give it back, or a preferential transfer, hey, you got paid more when we knew the ship was sinking, give it back, things like that. In this last round from January 9th, 15 advisory lawsuits dropped. So January 9th, 2023, 15 lawsuit. Erika's son, Thomas Zizzo Jr., Erika Girardi, Tom's daughter, Jacqueline Lira, David R. Lira, former partner and the son-in-law who's in all of the other stuff. Christopher Kamen, the former CFO. We'll look at that one. Keith Griffin, former attorney. Graham Lipsmith, Amanda McClintock, Howard B. Miller, Shirlene Fujimoto, David N. Bigelow, who is a lawyer with Girardi Keese, but it is so odd to me that his mistress was the Honorable Judge Trisha A. Bigelow, and then he's working with the David A. Bigelow. Is Bigelow that common of a last name? Maybe it is. Andre Sherman, John K. Courtney, Robert Finnerty, and Christopher Amos. Most of these seem to be other Girardi Keese attorneys that are all being sued for monies going towards them. On January 5th, 8 lawsuits were filed with regard to Metropolitan Life Insurance, Lakeside Golf Club, the Jonathan Club, the Wilshire Country Club, and the Bel Air Country Club, MGM Resorts International, for 2 things, and a company called Bye Bye Mold. I don't know. We're not digging into this one, but the Bel Air Country Club was $176,000 that they're trying to get back over a 7-year period. I haven't pulled the Jonathan Club and the Wilshire Country Club and all the rest of it. So let's see. On January 4th, 10 of these were filed for places like KCC Class Action Services. If you have, this is a preferential transfer. If you have seen any of the other lawsuits, this is a class action services company that has been brought up multiple times. They're trying to claw back money to, and I did a whole bunch of coverage about the legal lenders that's on the playlist. A trust, banks, PJA West Residential Association, All Delights Corrals, an individual, Loyola Law School, because he gave in the last 7 years over $124,000 to his law school in Los Angeles, Loyola High School. I didn't look at the amount of money on that one yet. On January 3rd, 9 were filed with Wynn Resorts, and then a whole bunch of companies, including like Lawyers for Justice PC and Rose Bowl operating in Utah Film Center and St. Mark's Day School. St. Mark's Day School sounds like a high school. I have questions. Is the law firm paying for like one of the partners' kids or something? I don't know. On December 29th, this all went down as I was traveling. On December 29th, 15 advisory actions were filed, including to Hook It Up Sports Fishing and West Edge Architects and Zion Trade Network and a number of individuals. On December 28th, 15 advisory actions were filed, including to construction companies, plumbing companies, other property locations, and Bravo Construction. On December 27th, 12 actions were filed to a wide variety of company. A lot of them seem to be involved in the horse area. Bantry Farms, Valkyrie Stud Farm. I don't think it has to do with the streamer. I think it has to do with racehorses. Big Z Ranch, Staffing Partners, Stats Company, and individuals. On December 23rd, 9 actions were filed, including to a number of entertainment and production groups, to Danny Levy Fine Gems for $40,000, and to MM Jewelry over a 7-year period, saying that MM Jewelers got an additional $209,000 over 2 payments for jewelry. So another $209,000 in jewelry. On December 22nd, 12 advisory actions were filed. Most of these seem to do with private planes, Business Aviation Management, Mather Aviation, Scott Aviation, Secure Aviation Solutions, Thornton Aircraft Company, Thornton Corporation, West Air Charter, Western Jet Aviation, STA Jets, BizJet International Sales and Support, and Castle and Cook Aviation Services. So it seems like they at least grouped them by business type in suing them, and that gives us the 105 lawsuits. These are all trying to get money back. The law firm paid these businesses, people, and entities. We think that these transfers are improper for a variety of reasons as the bankruptcy trustee, and we want them to give the money back. And then if they are creditors, and a lot of these are creditors, have I cross-hashed all of them? No, there's 105 of them. But a lot of these names are familiar to me because they are creditors. So their creditors saying, Tom Girardi didn't finish paying us, and the bankruptcy trustee is saying, and we're not going to. Oh, my kid is trying to get into the front door. I'm like, is it working? Because I hear him trying to get in the front door. Let me make sure he got in. I hear him. Okay. Kiddo did get in the front door. You're home? I'm streaming. No, it's okay. Sorry, as I yell at you, not my kiddo. All right, let's get into some of these. Should we look at Erika's first or Erika's son's first? Also, I should say to do the YouTube-y things, just to do the YouTube-y things. I looked it up. St. Mark's Day School is a religious private school. I'm not surprised, but who? Because Tom Girardi's kids are well adults. So in the last 7 years, what kiddos are going to private school? I'm curious. It could be a benefit that's improperly being paid for one of the attorneys at the firm to a secretary at the firm. I haven't pulled it up yet, but we'll see. So it could be a lot of things. I don't know yet. So, all right. Yes, could be grandkids. Could be a lot of things. Could be lunch meat, could be peaches. Are we going to do Erika's first or her son's first? Also, don't forget to do the YouTube-y things. It helps the channel. YouTube has been a little sus. Yesterday it was deleting views. It's mad about the cursey words. It's going through a little like new year, new me situation, and I don't love it. I don't love it when YouTube is like new year, new me. It's like, girl, no. Can we figured at least some out. I mean, I'm a very bad YouTuber, but we at least figured some of it out. I do the long form content, not the short form content. I am not the best at clickbaity things. I try to just tell you what I'm talking about. We don't hyper sensationalize things, and we just talk to you about the things. That is the we don't give people Teslas or private islands. These are not the things that catch the YouTube algorithm. So you doing the YouTubey things, thank you. It helps. I appreciate it. All right. Let us get into who's we're looking at, because I asked the chat, isn't the son a cop? Yes, the son is a cop. Erika's son. Let's see what he did. All right, let's do that first. That's what the chat voted for. This is a lawsuit inside of the bankruptcy. Lawsuits are allegations. This is an allegation over transfers of money. Let me be very clear. I'm going to swoop so I can be very clear. Let me be very clear. These are transfers that they are not saying the person knew that the transfer was improper, but the bankruptcy is saying that the person on the receiving end of it shouldn't have received it, and it should be given back. Not that they knew they shouldn't have received it, not that it is that under the bankruptcy it's improper, because they have 7 years to go back and try to recover those funds. So that's what it is. So let's pull this up. This is an advisory action in the Girardi Keese bankruptcy for bankruptcy trustee versus Thomas Zizzo. Complaint for avoidance and recovery of fraudulent transfers, preservation of fraudulent transfers, and disallowance of claims. So if you say you're getting any money or not, this doesn't mean that they are saying that they are a creditor and all the other stuff. So the chat's like, wait, we're not giving away Teslas? Shock face. All right. Let's go through, this is going to be the one time we go through the full complaint, and then we will go through the parts that are about each person specifically, not the entire complaint, because we're not going to need to go over it. They are all the same. I went through enough of them yesterday. They are mostly and largely cut and pasted. Jurisdiction, the bankruptcies in California, this is under the bankruptcy. Background parties and allegations common to all claims. In its heyday, this is a lawsuit because of everyone's fucking greed. It just serves so many purposes. This is a lawsuit because of the law firm's greed. In its heyday, Girardi Keese was one of the most successful plaintiffs' law firms in the country. a little smaller. It certainly was the preeminent plaintiff's firm in the state of California. The firm's founder, Thomas V. Girardi, was a legendary trial attorney, often viewed as the quote-unquote Clarence Darrow of the plaintiff's bar, reeling in hundreds of millions of dollars in settlements and jury verdicts. Girardi Keese's practice covered the universe of plaintiffs' cases ranging from personal injury, defective products, sexual abuse, and toxic torts to business, employment, and aviation law. But similar to when Toto pulled back the curtain to reveal that the Wizard of Oz was a hoax, the world eventually learned that Girardi Keese was nothing more than an illicit and felonious business operating to line the rather large pockets of Thomas, his wife, and numerous cohorts. While the trustee continues to investigate the magnitude of the fraud that spanned decades, it is obvious that millions of dollars of client funds were stolen and diverted to fund the lavish lifestyle of Thomas and other non-deserving parties. Carolyn's reading ramblings, he was compared to Darrow. Yes, to Darrow he was, often, because of his success. But at what point? The writing in this, by the way, this is the special litigator for the trustee. So this is these attorneys up here from Greenspoon and Martyr. These are a firm that was hired by the trustee to be the litigator for these types of causes of action. So lavish lifestyle. Every time we talk about Girardi Keese, lavish is going to come up. And we're going to use it synonymously with luxurious, but it's going to come up in every single one of these cases because where else the fuck did the money go? It went to like extravagant jewelry and private planes and cars and clothes, and it's expensive to be me and music videos and whatever else. I like that we've gotten a Wizard of Oz reference, unexpected. On December 18th, 2020, after discovering that Girardi Keese stole the settlement monies of the families who lost loved ones in the disastrous crash of Lion Air Flight JT610, petitioning creditors, this again lends credence to me saying that lawsuit, the divorce is a sham lawsuit, that lawsuit from Edelson PC is what pushed the domino over. I will continue to maintain that. I agree. Petitioning creditors Jill O'Callahan as successor in interest to James O'Callahan, Robert Keese, John Abazian, Erika Saldana, Virginia Antonio, and Kimberly Archie, collectively petitioning creditors, commenced an involuntary petition for Chapter 7 bankruptcy against debtor footnote 1. The petitioning creditors also filed an involuntary Chapter 7 bankruptcy petition against Thomas V. Girardi, which is currently pending in this other case. Thomas V. Girardi, the person, not the law firm. On December 24, 2020, petitioning creditors caused to be filed their motion for appointing interim trustee. The trustee was appointed. On January 13th, 2021, the court entered the bankruptcy. And let's see. Petition brings this action solely in her capacity as Chapter 7 trustee for the debtor's estate as its respective creditors and as successor in interest trustee of the Girardi Keese client trust account. I have the interest of the trust account. You took my shit, give it back. I, trust account, want my money back. To the extent that plaintiff hereby asserts claims under 11 U.S.C. 544B, plaintiff is informed and believed, and on that basis alleges that there exists more than one or more creditors holding unsecured claims allowable. Plaintiff was appointed under Chapter 7 after petition date. As a result, plaintiff does not have personal knowledge of the facts alleged herein. The facts alleged in this complaint that occurred prior to her appointment and therefore alleges those facts on information and belief. Plaintiff reserves the rights to amend this complaint. Plaintiff is informed and believes and alleges that defendant Thomas Zizzo is an individual residing within the jurisdiction of the court, California. Plaintiff further is informed and believes, and on that basis alleges, I'm not going to read that every time, or I intend not to, that Zizzo is the son of Erika Girardi, aka Erika Jayne, Thomas's wife, and is the stepson of Thomas Girardi, not Thomas Zizzo, not Thomas, her ex-husband Thomas. They're all fucking named Tom. And it makes it very confusing. Everybody's named Tom. Everybody's named Tom. So we're talking the stepson to Girardi, not the stepson. Yeah, obviously, not the stepson to their own father. At all relevant times, Zizzo was the initial transferee of the transfers alleged herein, or was the party for whose benefit the transfers were made. So money is going to the defendant in this cause of action that shouldn't be going to them, is what they're alleging. Let's see. During a time when Girardi Keese was in a precarious financial state and was not paying creditors, Girardi Keese began a systemic process of draining the available cash. This is where the problem is. The blood is in the water. The firm isn't paying its creditors, but they are making transfers out to other people. That is not allowed. Girardi Keese began a systemic process of draining the available cash, oftentimes consisting of stolen client trust funds, by and among other things, making distributions to certain preferred creditors, not allowed, or third parties from funds of Girardi Keese's estate. During the 7-year period prior to the petition date, with the assistance of various partners, employees, and family members, Thomas and Girardi Keese conspired by purpose and design to abscond and secrete the assets of Girardi Keese for the purpose of defrauding Girardi Keese's creditors. We're going to pay these people, but not those people. In virtually each instance, these transfers were made for less than reasonable equivalent value in return and during a time in which Girardi Keese was insolvent. That's key, because it's like, look, you already know this is not the operation in the normal operation. The firm's already not paying. And because the firm's already not paying, you can't be transferring these monies out here and there. So the firm was already insolvent or rendered insolvent as a result of the transfers, or when Girardi Keese was engaged or about to engage in a business or transaction for which the remaining assets were unreasonably small in relation to the transaction. Oftentimes, for instance, Girardi Keese used funds that should have been segregated in an IOTA account, interest on lawyers' trust accounts, meant to safeguard client funds. However, at all relevant times, Thomas and Girardi Keese used Girardi Keese's operating account and client accounts as if they were common depositories of not only Girardi Keese client funds, but also personal funds of Thomas, his family members, and other third parties. As a result of the commingling of funds in the Girardi Keese's general operating accounts, transfers from the client accounts and general operating accounts constitute transfers of funds in which GK had an interest. So the law firm is saying you are using the client funds and the general operating account of the business as your personal bank account, and you can't. And I am the business. Give me back my money now. Give it back. A principal manner in which the fraud and conspiracy of Thomas and Girardi Keese was able to operate and flourish was by obtaining numerous credit cards, oftentimes in the names of employees and non-employees, for personal use by Girardi Keese employees, Tom Girardi, his friends, family, and associates. Friends? I mean, I love my friends, but they don't have credit cards to my business unless they work for my business. Far and away, the largest single credit company used by Thomas and Girardi Keese was American Express. American Express would like to be excluded from this narrative. The following credit card accounts, each an American Express account, or collectively the AMEX accounts, were issued by AMEX to Tom, Girardi Keese, and various Girardi Keese employees, as well as third parties, including Erika and Zizzo. The kid who's a cop had a credit card for the law firm? Did they know it was a law firm card? Did it say the law firm? Did they think it was a personal card? Was it a personal card that was just being paid with law firm funds? I have questions. Here are all the accounts. So when we look at all these lawsuits, these are the names that all the lawsuits are happening on, and they're trying to pull back an amount of money to each of these people. So each of these individuals, including Christopher Kamen, hold on a fucking second. These are the credit cards. Wait, that's a different Christopher. These are the credit cards issued to the CFO. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. 17 American Express numbers issued to the CFO. 17? This is in 7 years. This is in the last 7-year period. 17 what is AMEX? Girl. 17 different cards issued to the CFO. What? The accountants in the chat, all of your heads are exploding. 17. Oh my God. 105 lawsuits and 17 American Express cards later. 17 AMX cards issued. And some of these AMX cards were the platinum ones that don't have a limit because that information was leaked on Twitter. Oh my God. Oh my God. What are they doing? Well, no, I know what they're doing. They're running it like a fucking RICO organization. They're just treating it. I'm not done. I'm not done. They're treating this law firm's money like a river. Like a river. I talked about this with, I don't remember which podcast I was talking about, Jen Shah, where I talked about that using money like a river. The money was just like in and out in a constant state of flux and was just being used. It wasn't really going anywhere. Well, now we know it was with regard to the CFO. It's alleged, we don't know, it's alleged in the criminal case that it's going to 5 different properties and half of it's, well, part of it, not half, two is not half of 10, Emily, but part of it's in the fucking Bahamas. The government says in its other, I'm glad we did the other ones first. Chat, you're so wise. You're like, let's do the fraud and a fraud first. Yes, it informs so much about this. The commentary on this case is better because we did that first. So much better. Because now we know that the government is alleging a $100 million fraud scheme. And this fucker out here has 17 different Amex cards from the goddamn law firm when you shouldn't. What the fuck? How is this okay? Dusty Den said, and nobody at AMX Corporate was like, I imagine that they were racking up tens of thousands, if not hundreds of thousands a month on these AMX and paying them off because they were using funds they shouldn't be using. And they're just like, are these all active accounts? It doesn't say. I choose you, Amanda. I'm losing my mind. I'm losing my mind. And yeah, let's see how many Erika had. But Erika, I guarantee you, doesn't have 7. Well, I can't guarantee. Keep reading, Emily. 17 for the CFO. 17 for the CFO. 1 for David Bigelow. I've got questions about the connection to the Honorable Justice Trisha A. Bigelow. 2 for David. 2 for you, David Lira. Good for you, David Lira. Emily's gotten punchy. You go, Glen Coco. 2 for David Lira. 1, 2, 3, 4, 5, 6. 6 for you, Erika Girardi. G&L Aviation is one of his other businesses. Your other business doesn't get a fucking credit card from your other business. Like the law firm's not running G&L Aviation. What? 2 in the name of Girardi Keese. Well, why did they need it? They're running everything through personally. 1, 2, 3, 4, 5, 6. 6 for you, Erika Girardi. Amber Galloway, good to see you, was saying Chris was one of our GK attorneys. His name is in here. His lawsuit's in here too. Had just one of the cards, but he is in here. None for you, graduators. But yes, he is in here too. What does the GNL stand for? Girardi and I don't know, something. I don't know what the L is. I would have to look it up. Excuse me. Girardi Keese had 2. 1 for Lipsmith, 1 for Miller, 2 for O'Callahan, 2 for John Girardi, who I think is the brother, 2 for Keith Griffin, 3 for Robert Finnerty, 1 to, oh, let's keep going. 1, 2, I've lost my mind today. How many fucking cards does Tom Girardi have? Okay. 1, 2, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. 14 for Tom Girardi. 14 for you, Tom Girardi. 1 for Thomas Layton. 2 for Erika Girardi's son, who is an LAPD officer and didn't work for the law firm, to my knowledge. And 1 for whoever Victor's is. Good. What is this? 12, 14 for Tom Girardi, 17 for the CFO. We should be giving out American Express cards. It's a lot of cards. I mean, they might be replacement cards, but over 7 years, that's a lot of cards. That's a lot of cards to move through in 7 years. With respect to Zizzo, this is the paragraph we're going to go look for in all the lawsuits. This is what I want to know is the amount of money. With respect to Zizzo, during the 7-year period prior to the petition date, Zizzo made charges or caused to be charged the Zizzo American Express in the amount of $237,000. This is over a period of 7 years, consisting of an aggregate amount of $78,000 during the 4-year period prior to the petition date and $2,000 during the 2-year period prior to the petition date. So in the last 2 years, not as much, but the petition was 2020. So not as much was being charged prior to, or 2021. So not as much was being charged prior to 2021, but $237,000 over 7 years charged on American Express cards that was like, hey, I'll pay off your bill. This is not a child. This is Erika Girardi's child, but this is an adult human. This is an adult human with a job. But the law firm can't just be paying you stuff. Girardi Keese made all of the payments to the American Express on the account. Don't worry, we'll get to Erika's. We'll get to how much was spent on the American Express cards. It's millions. With respect to the American Express fraudulent transfers, these were on entertainment, club memberships, meals, travel, luxury goods, vehicles, and other non-business purchases that solely benefited Zizzo, his family members, and friends and had no relation to the operation of the law firm. These weren't business expenses. So these are the causes of action. We're going to look at the causes of action together. We're not going to look at them for each and every case because there's 105. Anna put it very bluntly and very accurately, very succinctly, I should say. Trouble is, that wasn't Tom's money, right? This wouldn't be a problem. If Tom Girardi was getting paid by the law firm and getting paid and then was spending this money on Erika and Erika's son, it wouldn't be a problem. Get paid, spend your fucking money. Nobody cares. This wasn't your money. This is alleged to be client money. In some cases, we know it's client money because we could see it fucking moving right out of the client trust account. This is client money paying off the credit card bills of Tom Girardi's stepson, adult stepson. If Tom Girardi was paying these funds out of his personal pay, none of this is a problem. But it's coming out of the law firm, and that is the problem. Yay. Avoidance and recovery of fraudulent transfers. Plaintiff believes that during the 7-year period, these transfers were made to benefit Zizzo. Plaintiff alleges that they were made with the intent to hinder, delay, or defraud the creditors of Girardi Keese. That can be harder to show depending on what was going down with the law firm in that 7-year period, but he's treating this as his personal, and it's going to be a problem. The creditor, it's basically saying this money was given to pay whatever the restaurants, the travel of the stepson, and not going to pay the valid creditors of the law firm. Like the clients, plaintiff is informed and believes that during the 7-year transfers, they were voidable under California code. So these are not lawful transfers, and that the bankruptcy court can reach back 7 years by one or more creditors who held and hold unsecured claims against Girardi Keese, because there's not enough money to go around. So they're trying to void these out and bring the money back in so it can go to the creditors who it should go to. Plaintiff believes and alleges that plaintiff may avoid the AMEX 7-year transfers and recover the equivalent of value of said fraudulent transfers to benefit Girardi Keese's estate under this code section. Avoidance of recovery. Plaintiff believes that during the 4-year period, they were made without any equivalent value in exchange. It's not as if you were working for the law firm or the law firm was paying you for goods or services. These were they're alleging without value in exchange. And that Girardi Keese either was engaged in or about to engage in a business or transaction with the remaining assets that were unreasonably small in relation to the business transaction, or intended to incurred these debts beyond its ability to pay. Hey, you can't pay these debts on your own. Plaintiff is informed and believed and alleges that in the 4-year period, it violates this code and the money should be back to the law firm. Plaintiff believes that during the 4-year period, we violated this code and it should be undone and unwound. Avoidance and recovery of fraudulent transfers. So they're saying we have the grounds to go back and grab it. Here's the 2-year period. Plaintiff believes under this section that they are allowed to go back and grab the amount from the 2-year period. Avoidance of recovery under a separate code section. Hey, same for the 2-year period, freeze the money and go get it back for us. We are entitled to these funds. Recovery and avoidance of transfers. Zizzo is the transferee. Initial immediate and or otherwise of the American Express fraudulent transfers and the person for whose benefit it was. This went to this person. It should come back. 6th cause, preservation of transfers. 7th cause, disallowance of claims. Hey, pursuant to 11 USC 502D, to the extent that Zizzo has filed, or otherwise claims a claim as a Girardi Keese case, in the Girardi Keese case, the claim should be disallowed. So if you are claiming that you are a creditor, you shouldn't be allowed to. This is their reservation of rights. Hey, there might be more. And then they're asking for the appropriate relief, which is give us back the money, really. And the different causes of action have different portions of that. Not all of them are that many claims. It's a different combination of claims, but it is all, you weren't entitled to the monies that you received. It was made at a time when the law firm was already struggling. We know that the law firm was already struggling, so we can reach back 7 years and get that money back into the bankruptcy. This is a lot to be litigated, and this was only the first one that we looked at. So let's go look at the one against Erika and see how much these are all the ones we're looking at today are ones that are filed over paying American Express. So when you saw the chart with all the different American Express bills, every single one we're going through today is over American Express bills, except for the ones I cited earlier that we're dealing with payments to the jewelers and stuff like that. These are all AMEX payments. So here's the lawsuit against Erika Girardi. I should probably swoop so we can timestamp it. Here's the Girardi AMEX lawsuit. This is 3 causes of action: avoidance and recovery of fraudulent transfers, preservation of the transfers, and disallowance of claims. Erika has filed claims in these saying she's a creditor. Hey, I'm entitled to these things. And they're saying, no, you're not. You know who's not in any of these are the ex-wives. Why? Because they go way back further than 7 years. One of the ex-wives just had a settlement of her for thousands and thousands of dollars, like tens of thousands of dollars for her back spousal support. Karen Girardi. In one of the other cases, we haven't even gotten to that yet, but she's still getting some of her spousal support. Yes, before some of the clients get paid. Yes, that's annoying to me too. Well, I like the color of this gloss. Over time with talking, this is streamer issues. Over time with talking, it can get a little stickier. All right. This is what I get when I'm wearing my lip oil. I like the color, but hard to talk in for 3 hours. All right. Emily, these are not our problems. I know, chat. I know. And I love fraudulent transfers. Love this kind of case. It's crazy. Can you make the document wider? Yes, I can. This is so wild. Imperial Girl said, I'm sorry. No need to apologize, Imperial Girl. My mind is so blown. So much credit extended to one firm, and quite obviously the accounting is totally sketch. I don't think American Express knew that, but this is not the extent of the credit. They were working and operating on millions and millions of dollars of legal lenders as well. It wasn't just credit. It was legal lenders. And when they were extending legal lenders, Tom Girardi was promising, like, hey, we'll put the law firm building up as collateral. I'll put my house as collateral. And all of it was put up for the same things. And he was lying to people saying, no, nobody else has priority on this. Nobody else. It was like, I don't know. Like somebody promising every YouTube boxer that they're all going to get priority paid. It's Tom Girardi going, no, we'll put this as collateral. We'll put that as collateral. It's just, what a freaking mess. So we're going to zoom through the background and allegations because, again, they're the same, but similar to when Toto pulled back the curtain to reveal the Wizard of Oz was a hoax. So these are all going to be copy and pasted in every single one. The thing that's going to be different is how much went where. So with respect to Erika, during the 7-year period prior to the petition date, Girardi Keese made approximately 6 payments to Erika in the total aggregate amount of $97,000, consisting of, among other things, 2 payments to Erika in the total of $15,000 during a 4-year period, and the 4-year transfers, and within the 7-year transfers, see Exhibit A. With respect to fraudulent transfers, Erika was neither an attorney, employee, agent, consultant, or client. This is much less than I expected it would be on the American Express, because we've seen allegations in other lawsuits, I wonder if those reach further back in time. I just wonder if those reach beyond the 7 years, because these are 6 payments to Erika in the amount of $97,000. That is not as much as we've seen alleged in the other lawsuit where they're going after the millions. So I wonder if this is what they found after that lawsuit was filed. And I'm trying to see. Erika Jayne is an individual. At all times, Erika was the initial transferee for her benefit. Fine. Let's see. That's less than I'm very surprised. That's less than I thought. $97,000 in 7 years. And we'll go look at see what receipts they attach. Only 3 causes of action here. And let's see. These are the different checks. So are these not American Express? Are these just check numbers? Maybe they are, because the American Express is encompassed in that other lawsuit where they're going after her for millions. So these are the check numbers to Erika Girardi: 5,000, 10,000 to 15 in 4 years, and then 7 years, 2,000, 50,000, 10,000, 20,000 for 97,000. So these look like they are not American Express claims. These are check payments to her. Interesting. So that's it. Transfers for the amount of $97,000 in checks versus the American Express transfers. So notice we don't have the American Express chart that we get in the other cases here. That's already accommodated for in the other lawsuit. So that's not stunning. That's just a, hey, here's another $97,000. Should we go look and see what the CFO is getting? How many lawsuits does Erika Jayne have? You're asking hard. You're asking hard question. There's a bunch of them. There's a bunch of them. There is the now stayed RICO lawsuit with Edelson PC. There is the client that was like the girlfriend of Nicolas Cage that is suing the law firm and Erika because she didn't get paid. So there's the client lawsuit. There's another law firm lawsuit that just got dismissed. There are this is one of several lawsuits inside the bankruptcy. So at least 5, there's going to be more, but 5 on the top of my brain. I haven't had a chance to update a chart. I need a chart of the civil cases against Erika. Not all of them are as strong. These cases under the bankruptcy are all improper transfers. You got this money from the law firm, you need to give it back. The other things are not the law firm trying to get the money back, but others saying they have a right to get the money back. Let's go look at the CFO and how much they're alleging the CFO got after we saw those 17 fucking AMEX cards. Look, I have run businesses. I have worked in businesses. I have consulted with businesses. My husband ran a dental practice for 15 years. No, it wasn't bringing in hundreds of millions of dollars a year, and the overhead on dental is way higher than the overhead on this. But the CFO didn't have a business credit card because everything was just done. They didn't need one because it was mostly done through checks. There were very few credit cards issued to that business. It's just, as I'm looking at this in context of my own life and what I know, and then in other businesses, this is just, it blows my mind that this is what's going on. So let's look at Mr. I've got 17 AMEX in 7 years. Goodness. I want to see how much this is for. Cause wild. So Shady Millennial, I see your question. I'm grabbing it. I'm going to grab it at Q&A. I'm going to get to Q&A soon before we have to wrap a stream so I can like go eat, go to the bathroom, get ready for tomorrow. Members, we have a members only live stream coming up tomorrow. I'm going to keep you posted on time. We have a whole bunch of stuff happening tomorrow. So in the member spaces, there will be an update on that. I forgot to say that earlier, but you all get updates on that. So if you're a member on YouTube, you'll see it on your YouTube community tab. Over on Patreon, you'll get a notification on Patreon. All right. With respect to Cayman, during the 7-year period prior to the petition date, Girardi Keese made approximately 205 payments to Cayman in the total aggregate amount of $416,000, consisting of, among other things, approximately 118 payments in the amount of $281 during the 4-year period and 62 payments to $142,000 in the 2-year period. See Exhibit A. With respect to the fraudulent transfers, these were on account of entertainment, club memberships, meals, travel, luxury goods, vehicles, other non-business expenses. Another principal manner in which the fraud and conspiracy was able to operate was the AMEX cards. So these are American Express cards. The following credit cards were given, and then it lists again the credit cards. So yikes. With respect to Cayman during the 7-year period, a petition date Cayman made charges and caused to be charged to the Cayman AMEX accounts an aggregate amount of 22. Wait, these are different. Hold on. These are transfers of funds. Payments. These are like check payments. 205 payments, $416,000. Then we get to the American Express bills. And I almost read this number wrong because there's too many commas for my brain. 22 million fucking dollars in AMX charges in 7 years? Engaged 19 times? What is this? It's too late in the stream for this kind of information. When Emily does a first look. That says $22 million to the CFO in 7 years on the AMX in the kitchen with the candlestick. Oh my God. Did the CFO get more than Erika Jayne did? I have questions. I think the CFO. No. Okay, so sorry for the non housewives obsessed in the chat. 19 times is a reference to Teresa Giudice screaming and then flipping a table. So 17 AMX triggers the engaged 19 times. That it's not a literal statement. It is a housewives reference. So we needed to clarify that. The CFO. I thought you meant total for everyone, but this is just for the CFO. This is just for the CFO. This is one of 15 lawsuits. I'm not keeping track. But in 7 years, $22 million paid in Amex cards. But this is in addition to him stealing $10 million in a side fraud. And this is in addition to, that's alleged by the government. And this is in addition to 205 payments for $416,000. This is in addition to him getting paid like $300,000 a year. This is in addition to him stealing $10 million in a side fraud. If he's getting $22 million in AMX bills paid, why is he stealing $10 million in a side fraud? Hi, Travis. Do you think it's to fund his lavish lifestyle?
Yes, obviously.
You think everyone just wants more money? Okay. What's up, my child? I'm still streaming. I'm good, thank you. I should finish streaming. What information do you need from me? Okay. This is a CFO of a law firm frauding. We've had a lot of frauding chats today. The chat is motioning for DEFCON red. Travis, should we grant the chat's request for DEFCON red? It's when we make all the lights red. When there is fuckery afoot, like large fuckery. It has to be bigly amounts of fuckery. All right, Travis said yes. Oh, anything that counts as fuckery can be DEFCON red. The chat is demanding DEFCON red. Travis said motion granted. He actually said C. That's all he said. But motion. What? Bye. Will you just close my door? Thank you. Okay. Thank you for saying yes in 3 different languages. We appreciate you. Yeah, I think we go to DEFCON red For those of you that are new here, DEFCON Red is flashy. It's a little bit flashy. So when the music stops, the flashing will also stop, but it is a little flashy, but we love it. So just a flash warning, we are going to DEFCON Red in 3, 2, 1. We had to go red because $22 million. Seriously, what the fuck? We went to like DEFCON Death Star. We'll put the light back on. Seriously. We can't go to Code Fred. Fred's still mad at me. Fred's angry at me for going on vacation, and he has not come back into my office while I am in here since we got back from vacation. We've never gone on vacation that long. The paw nerds are angry with me. They're not angry with Travis. They're just angry with me. So they're going to be spending that out with him. No, the $22 million chat is just for one. Oh no, Fred should get an American Express. This 22 million, this is just for the CFO. This lawsuit is just for the CFO. This is just the CFO. This is one of 105 lawsuits saying that the CFO got over $22 million. You know what the bankruptcy trustee is not going to get back? This $22 million. Plus, this is $22 million plus because there's also 417 up here. It's 22 million, 140. It's like 22.5 million. So this is 22 million over 7 years, 12 million over 4 years, 3 million in the last 2 years. In addition to the side front, dude, the CFO's like rolling. He's like, yeah, my credit card bills are paid. Like my money don't jiggle, it folds. The American Express bills are just being paid by the firm. I got 17 fucking cars. We're buying $100,000 purses and flying on private jets. But let me also go ahead and steal $10 million. You know what the kicker is? I wonder if the CFO is like, I wasn't stealing that $10 million. I was just offshoring it. I was part of the process of washing it. I wasn't just using it for myself. This is where I was really stealing the money from. It's so much money. Laura M. Motion grant. I'm making this a motion and then granting it. CFO, Chief Fraudulent Officer. Yes, I might shorten it to Chief Fraud Officer. But yes, Chief Fraud Chief Fraud Officer. But his money doesn't fold, it swipes. That's true. And it's not even his money. It's their fucking clients' money. It's their clients' money. People who are injured. Like they're stealing from plaintiffs' clients. People who were injured, sometimes catastrophically. They're not stealing from banks or businesses that have insurance that can recover, whose CEOs are still resting at night unless you're in Wells Fargo. And then apparently one of them, not the CEO, it was a vice president, is peeing on someone on an airplane. That's a story that's not legally related, so it didn't make it into the roundup, but I couldn't stop talking about it with my family yesterday. I'm like, what goes wrong that you pee on someone on an airplane and get arrested for it? But that's another conversation. But this is stealing from people who are catastrophically injured, who this money changes their lives. This is not stealing from crypto investors. It's different. No one should be stolen from, to be sure. But there are levels of moral fuck you. This is awful. There are levels. What about the airplane? Oh, a VP of Wells Fargo is alleged to have peed on someone on an airplane and got arrested when they got off the flight and has since been removed from Wells Fargo. Yes, that would be a code yellow indeed. I was reading the stories about it yesterday. It just okay. We'll revisit the Wells Fargo story. But anyway, they've been arrested in India. It was a flight from New York to Mumbai. They are a VP in the office in India. It's just a whole thing. It's all, yes, peed on a 76-year-old woman next to them on the flight. Apparently they were largely intoxicated. I can imagine that that's the only way that story comes about. Okay, we're not done. There's more. They're saying that this included entertainment. I mean, apparently all of the entertainment, club memberships, meals, travel, luxury goods, vehicles, and other non-business purchases that solely benefited Cayman, his family, and family members. With respect to Cayman, during a 90-day period prior to the petition date, Girardi Keese made transfers of property in the form of approximately 4 payments to Cayman during a 90-day period for $1,000. So right as it was going down. All right. We've got 1, 2, 3, 4, 5. This is all the claims. 6, 7 claims. So 8 claims. Oh, and disallowance of claims, like you're not getting paid. This is obvious. You're not getting paid, came in. Let's go see what their bookkeeping looks like in Exhibit A. These are the receipts. These are 90-day total. Those are checks. Some of these are not checks. I don't know where these are coming from. Receipts and disbursements. Anyway, this is their accounting on it. I'm not going to break it down any more than that. 2 years, including 90 days, 142,000 in payments. Let's see. 4 years, including 90 day and 2 years, 281,000. I just want to see if we're going to get the AMEX. These are payments. I want to see if we're going to get, there's the 416, 7-year. Are the American Express payments in here? Sum of credit, 260,000. Sum of debit, 3,360,760. Sum of credits, sum of debits. Where are these all? Oh, no more than that. Well, oh, there it is. Sum of debits. So these are going to be the payments, I guess, to the 2-year, 4-year, 7-year. Emily, look at the top. So these are the American Express card holders, net debits on the American Express card. What I wasn't expecting today is that we were going to get to $22 million to the CFO and American Express cards, because everyone's made I have not seen this reported anywhere. Everyone's made a very big deal about what Erika Girardi got or not got. We need to be talking way more about the CFO. $10 million side fraud and $22 million in alleged American Express payoffs. And yes, for all of you in the chat who are like, why are all the receipts in $250 denominations? I have no fucking clue. I have no idea. These are payments outside of payroll. So what the fuck are they for? Like, they're outside. What are they? They're outside of payroll. So, I mean, there's no morally excusing where we're at with Erika Girardi benefiting. But Erika Girardi is not the only one, and maybe not the tip of the spear in any of this. So with these receipts, I think this is just bookkeeping. Remember, the bookkeeper's in charge of putting this in. So 250 seems like this seems like the bookkeeper just putting shit in to me. So I'm not going to guess about what it might be for, because I don't think it's for anything legitimate, and it's being alleged that it's not for anything legitimate. Should we go look at how much money they're alleging Tom's daughter got? Because now we're riding. We're not done. Let's see what they're trying to claw back from Tom's daughter, Jacqueline Lira, and Tom's son-in-law. Because this is why we do first looks. What I wasn't expecting was $22 million to the fucking CFO. This is Jacqueline Ann Lira, aka Jacqueline Ann Girardi, Tom's daughter. Let's see what they're alleging or what they're trying to get back from her. Plaintiff believes and alleges that Jacqueline Ann Lira, aka Jacqueline Ann Girardi, is an individual residing within the jurisdiction. Believes that Jacqueline is the daughter of Thomas and is married to David Lira, a partner employed by Girardi Keese. At all times, Jacqueline was the initial transferee during a time when Girardi Keese was in a precarious financial state. Same allegations as above. With respect to Jacqueline, on August 2nd, 2012, the Superior Court of San Bernardino entered into a split. Oh, this is the lottery case. Interesting. All right. Entered into a stipulation and order authorizing California lottery disbursements and lottery winnings. We've already seen these getting clawed back with regard to Erika Girardi. And what happened, this is in this is in shorthand. Erika Girardi and Jacqueline Lira, the wives, were getting the disbursements that were meant to go to the law firm as client fees. You're not allowed to do that. So it's end routing the law firm, and the money's being distributed directly to them from the winnings from this case. So this was signed off on by the court. It doesn't mean it's proper. It's not proper. So they're trying to claw back this settlement agreement. That makes sense. In accordance with the August 2nd order, the Superior Court approved that settlement agreement, the Marston settlement agreement dated June 12th, 2012, by and between Maurice Marston and Natalie Marston Salem. On the other hand, true and correct copy is attached as Exhibit A. Pursuant to the settlement, Natalie Marston was entitled to receive 20 annual payments of $260,000 for 20 years from the California Lottery Commission. Natalie duly assigned her right to receive lottery payments authorized for the calendar year of 2012 to 4 individuals, including Jacqueline, who was entitled to receive 13.34 of the lottery payments, a payment of $34,000 for the calendar year of 2012, and assigned for 2013 through 2025, 10% of the lottery payments or an annual payment of $26,000 for the calendar years 2013 through 2025. Together with the 2012 lottery payments. So that's saying that Jacqueline Lira is getting these funds that should be going to the law firm. Natalie would receive 100%, and Natalie would receive 100% of lottery payments or annual payments from the calendar year 2026 through 2028. On June 19th, Jacqueline executed the payment setup and executed it down below. True and correct copy is attached. Plaintiff is alleging that the payments made to Jacqueline are property of Girardi Keese's estate, and they were on account of attorney's fees rendered and expenses incurred by Girardi Keese in his representation of Maurice Marston in the Marston action, to which attorney's fees and expenses were fraudulently transferred and diverted by Girardi Keese to Jacqueline. So they're saying, look, she shouldn't have got it. We need it all back. With respect to Jacqueline, during the 7-year period, Jacqueline received 8 payments from the California Lottery Commission, aggregating $208,000. 5 payments in the 4-year period for $130,000. 3 payments in the 2-year period for $78,000. So those are from the lottery payments. Erika Girardi has previously been sued over these to get them back. So these are not American Express payments. These are the structured lottery settlement where, again, legal fees that were supposed to go into the law firm were diverted to the partner Lira's wife, who is Tom Girardi's daughter. So let's see. And then they attached that structured settlement agreement, which I don't think we need to go through. We went through this. And if you want more coverage of the lottery settlement, I went through this, not the whole settlement agreement, but we went through parts of it when Erika got sued for this early last year. So this is this person's entitled to the payments, and they're splitting the payments from the lottery, 60%. They're 13.34 to Jacqueline, 13 to Erika, 13 to Basil. And then this is the next set of structured settlements, which we've already just listed through. So trying to claw back those. Erika Girardi had already given over some of those, like the things that were scheduled to be paid in 2021 and I believe 2022 already went back into Girardi Keese from Erika. She had already surrendered the rights to those. So let's see what, my nose is starting to run way more. Let's see what David Lira got, or they're alleging David Lira got. Let's go and see if this is over American Express cards or something else. David Lira, son-in-law, former partner in the firm, who we heard a lot about earlier in the day because David Lira's name is the one that came up with the attorneys all having a conversation that he's going to stay the proceedings because he seems to think, all based on hearsay, seems to think that new criminal allegations are coming. So let's go see what the bankruptcy trustee is trying to claw back from David Lira, former partner at Girardi Keese and Tom Girardi's son-in-law. With respect to Lira, during the 7-year period prior to the petition, Girardi Keese made approximately 508 payments to Lira and aggregating $1.3 million, consisting of, among other things, 234 or 43 payments to Lira in the total of $528,000, and then in the 2-year payment, 79 payments for $201,000. With respect to the fraudulent transfer, these were on account of entertainment, club memberships, meals, travel, luxury good vehicles, and other non-business expenses solely to benefit Lira. So this is outside of a paycheck, outside of expenses being paid for business travel. Another principal matter in which the fraud and conspiracy of Tom Girardi and GK was able to go through was through the American Express bills. So these are payments. First, let's see if there's any American Express payments on the credit card. With respect to Lira, during the 7-year period prior to the petition date, Lira made charges or caused to be charged on the American Express a total amount of $586,000. Well, compared to the CFO, that seems positively restrained, consisting of, among other things, charges in a total of aggregate of $335 in the 4-year period and $168 in the 2-year period. So this is a total of $586,000 of American Express charges and then a transfer of additional payments in the amount of $1.3 million that they are saying is outside of what should have been paid. Kaylin Ann, it's like a mob family. That's exactly what has been alleged, that they're operating this like a criminal organization, not like a law firm. So they're going to have some accounting down here at the bottom. And then I'm going to move on to questions. I think these are all the ones we wanted to look at. So these are the disbursement checks. You see the check number. It's interesting because some of these, I would have to go look. Some of these, I don't know if some of these check numbers are the same, and amounts are the same. So how they are totaling this up, I've got questions, but this is for the lawyers to litigate in court. This isn't a foregone conclusion. This is something that will be litigated. We'll see if this will get litigated or if we'll see what drops first, whether it will be this answering to this or others. Some of these checks are in the hundreds of thousands of dollars amounts. And again, they're saying this is outside of proper payroll because you can see somebody getting attorney's fees in this amount after payments are made. Let's say, and there's the American Express bills. All right. We should just go to questions. I've been live for like 3.5 hours, but this is what all of these are. These are all transfers and conveyances. Hey, you shouldn't have been paid this when you were paid. We're trying to claw back in that 7-year period. So I've got questions. You've got questions. We've got super chats we need to get to. Man, oh man, oh man, oh man. Cheryl, what a rude awakening all these criminals will have when they have to live out their live like the rest of us, and that lavish, extravagant life is gone. I mean, it's gonna be wild. It's gonna be wild. These McLinda said maybe statement numbers. Those were all check numbers because they were labeled as such. The statements were later, but again, these will all be litigated, and I am not going to go through them too much. Again, it is a first look. So I've got questions. You've got questions. We need to fact around and find out in a good way because the Girardi case is going to fact around and find out in a bad way. Look, it's time for questions, and then it's time for me to go have lunch and let the members know about our timing for tomorrow. Whew. Valkyrie Art said, I know that Erika benefited from Tom's fraud, but what do people want to go so hard after her? I think some of that's because she's the one on TV. I also think it's because she's like, has said some things that are less than flattering on social media and has said, we don't even know if these victims got paid and we don't know this and we don't know this and that and the next thing. And a lot of this wasn't known. We knew that Erika Girardi was benefiting from these things. Lunch, Emily, it's dinner time. Well, I haven't had lunch yet, so it's lunchtime. It's like dinner time. It's time for an appetizer and then hold out till dinner. Question, has there been any Toddy Halo lawsuit updates? I haven't looked since I've been back from break. There might be, but we need to. And the chat can also give thoughts on why the public has gone harder after Erika. I think her behavior on social has something to do with it. I also think she's the one on TV. She's the one that's flaunting the lifestyle. She's the one that's like, I got all the planes. It's expensive to be me. I'm talking about my $40,000 a month glam. I think it's easier to see the lavish lifestyle when it's in your face on television. None of us know who the fuck Christopher Kamen was or is, but apparently allegedly racking up $22 million in American Express bills over 4 years, but we don't see it. It's not as visceral as Erika being like, I don't know, which jet are we taking? The big one or the small one? It's different. You have a different response to it than when she's wearing the Jaguar ring and the scandal earrings. It's not as visceral. So I'd like to argue that I'm a good habit. We learn something and we have fun. We learn something and we have fun. Steeler said, wait, you mean I'm not going to win a private island watching you? Not yet. And I've not had any sponsors suggest it. Jen Shaw is acting like she isn't going to prison and showing remorse to her victims. I mean, she's going to prison, whether she acts like it or not, we'll see, but that's happening. Let's see. Question, when it comes to Girardi and the defendant in the Idaho murder cases, if they are convicted after the time is served, can they go back to working with law? No. Well, Girardi, we'll see what happens with Girardi. The Idaho The Idaho murder suspect, if the Idaho murder suspect is convicted, they will never be out of prison again. If they are not sentenced to death, because they have not determined yet if the death penalty will be asked for in that case. So no, they will never do anything again at 28 years old. If they are convicted, that is the end. Go to prison. Do not pass go. If it is life without parole. With Girardi, he's been disbarred and he's said he has dementia. So there's nothing that he will be engaging with either. If he is prosecuted, we will see what happens. He is in his 80s. We will see. We will see. Old Line Red said she's on TV because of the lifestyle. She is. I mean, what Tom Girardi was doing got her on TV, but the same can be said too for Jen Shah. Would Jen Shah have been on Real Housewives of Salt Lake City without the lavish lifestyle? No. Linda, please, Emily, can you tell me Erika Girardi is going to prison? I can't tell you that. There's nothing that indicates whether or not she knew enough to be indicted. They've indicted the CFO. I would imagine if we see indictments, what we're going to see, and again, this hasn't happened yet, but I imagine when we see indictments, we've seen the CFO and we know more is coming for the CFO. We're going to see the other lawyers in the firm. There has been nothing that we've seen. I find it morally distasteful as well, but there has been nothing that we have seen that shows that Erika actively engaged in this. It's alleged in the Edelson PC case that her putting on the lavish lifestyle is part of what kept bringing money into the scheme. But we have not seen enough to show that she knew enough to be in this conspiracy. Even if she benefited. So I can't tell you that. There's definitely not enough money and nobody's, well, other than the CFO, nobody's been indicted. So we'll see what happens. Question, how is this going to affect Tom's career as a police officer? I imagine they will have questions like, hey, what's going on with this? But him having a credit card paid for without more, especially if he pays it back, I don't know if this kind of civil lawsuit will be a huge problem. So let's see. Question. Excuse me. That was awful. When you've been talking for so long, sometimes things happen. Apologies. Will you see Real Housewives of Prison with separate storylines? I mean, life, like Love After Lockup and stuff does it. Will we see like what Jen Shah gets up to while she's in custody? I don't know. We saw interviews with Anna Delvey from prison, and we're seeing that Anna Delvey is trying to get a reality TV show. I don't know. It'll be interesting to see. And then we got, Elizabeth Holmes potentially going to the same federal camp as Jen Shah. Are they going to be working on business ideas together? Question, can we have another food lawsuit? I need the laughter. I will try to add something lighter for later in the week for sure. Things just keep happening. I haven't even had a chance to prep Thursday's show yet, but there's definitely some stuff I want to talk to, and we will do less topics and more questions on Thursday. True said, Emily, are any of those credit cards in the name of anyone who worked for the California State Bar Association? The AMEX cards all seem to be lawyers that worked for the firm in the last 7 years. So I haven't seen anything like that, or anything that indicates that. 22 million, surely you can't be serious. I know, it's wild. Question, if Erika Jayne is not included in the criminal indictments, could that absolve her and get her dismissed in the RICO case? Civil RICO and criminal RICO, different theories, different standards. So no, she could make a motion to dismiss, but no, it wouldn't absolutely get her automatically dismissed, because the civil case is brought by Edelson PC on behalf of clients, different than the federal case. So what they will choose to do, we will see. Question, is it true that the judge in the Murdaugh trial is only allowing Court TV to stream live? Saw Mandy mentioned it on Twitter. Not sure if I can face the number of breaks they take. I don't know. I will take a look. I have not seen anything of that. However, a lot of the trials that we have watched have been Court TV is the only pool camera. The Court TV cameras were the only pool cameras in the Waukesha case with Daryl Brooks. So Court TV had the pool camera. They were in charge of the cameras and the technology. Court TV was really respectful of making sure that sensitive information was not shown on screen, was not televised, and they've done a good job with that. So if Court TV are the only cameras in the courtroom. They will be a pool camera where other organizations will then be able to stream it. So it won't be exclusively theirs. It will be a pool stream. I hope that answers it. Thank you for asking the question, because then we will see other independent stations streaming it from Court TV's feed in addition to Court TV's feed. So that is generally how that works with pool cameras. But again, Court TV in the Darrell Brooks case did an excellent job of making sure that sensitive evidence that was shown was never shown on TV, that minors were never shown on TV. They've really proven that they are able to navigate sensitive cases, and this will be a case like that. So I'm old enough to remember when Court TV cameras were the only cameras. Well, they're still the only cameras sometimes, but now we have the benefit of pooling it and streaming it all over. So yes. Question, are you going to cover the Lori Vallow and Chad Daybell case? I don't know. I'm still undecided. It's a very difficult case, and there's a lot to catch up on. I don't know if I have the capacity to get caught up on it. So it's on my radar, but I have not decided. I'm not going to say no, but I'm also not to yes. There's a lot going on. We've got the Murdaugh trial coming up first, and that's kind of where my focus is on that. So we will see. I just don't know. I just don't know. Grass Folk said email is now Semaphore Brands. That's my email that gets to my team. So my public facing email is a great way to get to me. We see those emails. Do we get to respond to all of them? No, but do we see them? Yes. So we answered this earlier. Thank you. Thank you. As a fellow child of the 90s, I'm mad I didn't realize that Baz and Leo have worked together at least twice. Baz did The Great Gatsby as well. Yes. Question, which case is worse? I don't really know, and it feels gruesome to vote. They're different. They're different cases, and so it's hard. Girardi has way more money taken from clients and more clients affected, but the Murdaugh case has multiple murders that are looped into it. So they're bad. They're both horrible in different ways. I don't know if we can apportion a worse. They're both horrible in different ways. The chat asked, let's see, where is it? Does Court TV have a monopoly on the court cameras? It's not really a monopoly because they have to pool it and they don't get the copyright over it. So that stream has to be allowed to be streamed by others. So no, not a monopoly, and you can only watch it on Court TV. It's not an exclusive like that, if that makes sense. Question, can you look into the lawsuit against Kyle Richards' husband? It's on my radar. I just have not had a chance yet. Whether or not the victim of child exploitation is recognizable now is irrelevant. The child knows it's him every time he sees it. Lisa Lamb, that's a very fair point when we were talking about the Nirvana Baby. It's just whether it's exploitative or not is legally a very big question. PDF recommendation, Nitro. I will make a note and take a look. I think about this with claim denials. I don't want to teach people how to potentially insurance fraud better. Yes, I don't want to teach people how to crime better by sharing what I know, but also I try to help. Replay crew, I heard the CCR song sung, "There's a baboon on the right" as a joke once, and now it's stuck in my head. Uh-oh, I could see that sticking in my head. That's one of those lyrics that is very, very, very commonly misunderstood. Jess said, "What? You're not Mr. Beast?" Bamboozled. I know, I am substantially older than Mr. Beast and way shorter. Jimmy is really, really tall. I think he's like 6'2". The one time I met him in person, I was like, holy shit, you're really, really tall. I get that. But okay, actually tall. I was surprised at how tall he was. But yes, no, definitely not Mr. Beast, not giving away money like Mr. Beast. Do not have the capacity to make a multi-million-dollar recreation of Squid Game. It's not even the way my brain works. His brain works that way. Mine does not. Keith Griffin sounds like Peter Griffin. I mean, it's Beats Kill Bean. I put another K in there. I'm sorry, my brain. As it gets worse as I'm tired. As an accountant, this makes me nauseous, but I also can't describe how much I would love to dig in and sort through the money trail. Me. This case is horrible. I'm fascinated. I can't stop. I wish I had all the records to go through. I don't have the time, but I wish I did. I'm so curious. I want to. I want to know it all. I want to know everything about this case. It's horrific. There are so many people that are damaged in the Girardi case, but I want to know everything. So I understand the like intellectual curiosity and moral outrage meeting somewhere in the middle. So I get it. I taught my boys be mindful of who you are hanging around because you never want to be on the wrong side of a desperate person doing a desperate thing. It's true. One of the things I used to say in a lot of cases when we would talk to colleagues, they'd be like, "What's this case?" I'm like, "Don't be where you're not supposed to be." And it was a lot of people who didn't want to involve law enforcement when law enforcement needed to be involved because they were where they weren't supposed to be when they weren't supposed to be there. And if you're where you're not supposed to be when you're not supposed to be there, and something bad happens to you, you generally don't want to call the police because you're like, "Shit, I'm not supposed to be here, and if I have to call the police right now, they're going to know I'm here." So don't be where you're not supposed to be, man. The thunder rolls. It's a whole song. Being where you're not supposed to be. All right. Question: if Erika is morally guilty because she benefited from Tom's theft, what about his exes and mistress? Yeah. What about their moral responsibilities, regardless of law? Look, it's a very fair question. The judge mistress tried to give back some, didn't give it all back, still used Tom Girardi's money to buy a condo and knew he was married and she was engaged. Like, there's a whole lot of, like, let's have a conversation about who's right and wrong. The rest of them just aren't on TV. And the exes, I think, I truly don't have the evidence to show that Erika knew that Tom wasn't paying the American Express card from his payment. Like, hey, was Tom getting money personally and paying the American Express card from what he's being paid from the firm or paying it from firm funds? I don't know that Erika knew that distinction. I just don't. His law firm was making so much money. We heard it in the Jay Edelson interview. It's preposterous to believe that this money's gone because they were making so much money. Who would believe it? And you see this with fraud cases all the time. Not all the time, often. It's like, I didn't think that person would defraud me. They're rich. Why do they need to defraud me? Jen Shah. Why would Jen Shah need to defraud anybody? Husband's making hundreds of thousands of dollars a year. It looks like her life is great, or at least financially well off and financially advantaged. Why would they need to defraud? And then you're like, well, that's where this is all coming from. Question: why did they seal the Girardi case? How is that in the best interest of the public? Not necessarily in the best interest of the public. That's not the overriding consideration. The overriding consideration is there are legal factors to determine when something should be sealed and not, and you can object to it. And in the Shah case, we're going to see some things unsealed, but the public's right to know is not on that list. So when it comes to the Girardi, not the Girardi lawyers RICO suit with Edelson PC, the whole case isn't sealed. It was just a particular motion that was sealed regarding a pending criminal investigation, and that is a thing that's not uncommon to be sealed and appropriate to be sealed. So sealing a whole case, like a broad seal of everything, is a much higher standard than sealing a particular document or two. And then the accountant, there's a number of things still sealed in the accountant's case as well. And I imagine that those are still sealed because there are other investigations that are ongoing and coming, and you don't want to tip people off. I think everybody knows these indictments are coming now. It's not hidden in any of these filings. Question: I know Jen Shah is going to prison, but will you cover the sentencing memo if additional stuff is unredacted? Yes. Also, was 6.6 million additional restitution from the original 9? No, it's a portion of the 9. So 9 total, 6.5 of it is forfeiture, is how I read it. So Ricky said, wanted to thank you, Rob and Ian, for sharing your ADHD brains. You're welcome. Getting tested for ADD soon. And if it had been brought up before I found you guys, I wouldn't never have considered it. You guys are amazing. Well, thank you. We're here to normalize all the brains being different because brains are different. And sometimes it's frustrating. My kid and I had this conversation yesterday. This happens. I don't know if this is a non-ADHD thing. It's always happened to me. Sometimes somebody will say something and you'll get stuck in your brain. Like, oh, I'll see you Wednesday. And then you'll miss an appointment on Tuesday because they said, I'll see you Wednesday, though they might have been mistaken, though it might be on your calendar for Tuesday. It's now fixed in your brain that this is immovable. And this happens to me with certain things, pronunciations of things that get fixed in my brain and are unmovable. And this happened to my kiddo. He's like, I'm so frustrated because I thought it was this and it ended up being this. And I'm like, buddy, it's fine. We can fix it. You're not that late. Whatever. It's fine. But he's like, I'm just so frustrated because I thought it was this, but then it's over here and it's not. And I'm like, ADHD brains sometimes are funny. You just need to give yourself a little bit of grace and we will figure it out. But sometimes those things just get fixed. It was in my calendar for Tuesday, but in my brain it was for Thursday, and my brain overrides because then I can't even see it on my calendar for Tuesday because my brain thinks it's supposed to be on Thursday and my brain is stuck at that point. Supposed to be there. So we talk about this all the time. Just it's helpful to give grace and to normalize because I think a big part of ADHD is shame and being not knowing how to speak up and ask for help. And that still takes me time with my team. And I will tell my team regularly and often, I need you to do this because my brain will do this. And the more I understand my brain, the more I can work around it and work with it and ask people to help me. And I also get to work for myself. But even if I didn't work for myself, having the ability to communicate openly, like, when my door is shut, please don't interrupt me because you'll literally derail me for 2.5 hours and I will never get anything done. Like, just put a sticky on the door to come see me when you're done or something. Like, please, unless it's an emergency, do not interrupt me because fuck, I will lose the rest of the day. And never set me an appointment at the afternoon because then I'll lose my entire day thinking I'm going to miss the afternoon appointment and then I will lose an entire day anyway. Only in the morning. We don't do things in the afternoon. Do you think between Girardi and the Murdaugh case that there might be more safeguards proposed to protect client funds from fraud activity? There's supposed to be safeguards. These attorneys are, well, Girardi, it seems like nobody was looking, but yes, the California bar just did something. I saw it. The California bar is doing things. Let's see if it might be on Law 360. Because I saw Jay Edelson tweeting about it. Let me see if there's anything that grabs. Let's see. Girardi Keese trustee sues firm's former attorneys for $9.4 million. So that totaled the firm's attorneys. Hey, thank you, Law 360. It looks like they were going through this. This came down at 4:17 p.m. Eastern today while I was streaming. So they were going through these documents that dropped yesterday as well. So it looks like here, let's, but wait, there's more. Brandon Lowry, did you get to the $22 million yet? Because holy fucking shit, man. Let's see. 10 former Girardi Keese attorneys may owe $9.4 million to the firm to repay checks and personal charges on their company credit card. The firm's bankruptcy trustee alleged in a series of advisory actions filed last week. There's 105 of those. In all, the trustee has filed over 100 complaints since late December, 105 in total, to recoup more than $90 million in alleged fraudulent transfers made by the firm. Thank you, Brandon Lowry, for adding them the fuck up, because I haven't had a chance to do it yet. The filings use more than 11,700 transactions to paint a picture of a firm that spent tens of millions of dollars on luxuries, lost tens of millions more to fraud, and allowed employees to make personal use of its money and resources. Some of the payments continued until just days and weeks before the firm crumbled. Let's see. The firm's former CEO, Christopher Kamen, was arrested. They don't talk about that. Miller's recent complaints show over the past 7 years a maximum limit for fraudulent transfer claims. The firm paid employees gambling debts. That's where the Win stuff is coming from. What? The firm paid employees gambling debts at casinos on the Las Vegas Strip. Girardi Keese paid $115,000 to the Wynn Resorts, $205,000 to MGM, and $520,000 to the Cosmopolitan owner, Blackstone Real Estate. The firm also paid $5 million to businesses belonging to George Hatcher, a friend of Girardi's with a criminal history. Former Girardi Keese attorney Christopher Amis allegedly received over $421,000 in payments and charged $1.7 million to the company's AMEX, the most of any individual lawyer at the firm. Another attorney at the firm, Girardi's son-in-law, received $528,000 and charged over $586,000, but the CFO charged over $22 million. I'm glad that they added up. Thank you, Brandon, for adding it up. I bet the CFO gets their own story. Okay, let's go see what the California bar did. So much is happening today. I told you today was going to be a long one, but we're almost done. The mods are like, please don't. Please don't. There is an update on Nate, the lawyer from Law 360. Damn it, Emily. Stop looking at article. Boozy must have responded. Nate the lawyer launched classic slap suit, court told. The New Jersey resident we're going to have to do this on Thursday. Here's a preview. Y'all still come back. Y'all promise in the chat that you'll still come back on Thursday. We'll talk about this more on Thursday. This is what you get for staying to the end. The New Jersey resident behind the social media watchdog fired back at an attorney suing him for defamation, calling the suit a classic slap, saying that the charges against him are entirely without merit. Did you read your own tweets, Boozy? Nathaniel Brody, an attorney who runs a 274,000 subscriber Nate the Lawyer YouTube channel, sued Christopher Boozy, who runs Bot Sentinel, for defamation. Didn't we read Boozy's tweet? Some of the challenged tweets are constitutionally protected expressions of pure opinion or opinions based on based upon disclosed facts. Others are statements of fact, but are not materially false. This is a meritless lawsuit. The attorney for Boozy said in an email to Law 360, as our motion shows, all of Brody's claims against Boozy fail as a matter of law, and the court should dismiss the case with prejudice. So they are it sounds like they're bringing a motion to dismiss based on the New Jersey slap statute. Boozy said he found himself in the sights of Brody when he published a report on YouTube accounts that violated the site's policies, in which he targeted accounts connected to Brody's. I mean, were they connected? The two got into an online spat, that's accurate, in September 2022 that gave rise to the suit, according to Bot Sentinel's website. It is a platform designed to help fight disinformation and targeted harassment online. We'll keep our thoughts to ourselves and talk about this more on Thursday, I think. Boozy wrote a tweet questioning whether Brody was an attorney because he could not find the attorney in the online database. And then it goes on. Boozy acknowledged accusing Brody of being a grifter for stoking outrage over the fight between the two and using it to canvass for donations. I mean, that's not the source of the defamation, though. Calling Nate a grifter for getting super chats to talk about the fight online is not the source of the defamation. But he argued that Nate's claim against him failed to show actual malice behind the accusation. Well, the grifter accusation, I don't think is what they're saying. Brody himself said that the tactic was a good grift and called the donations he was getting boozy bucks. That's true. He did call them boozy bucks. The suit should be dismissed with prejudice, he argued, as there is no way to fix Brody's case. Generally, if cases get dismissed on slap grounds, it normally ends the case. I'll have to look at New Jersey's slap law. Let's see. Ron Coleman responded. Ron Coleman, counsel for Brody, called the motion aggressive, but said it was in line with what he and Brody expected when they filed the suit. He also defended the validity of the suit. This is not a slap case. This is not a slap claim. This is meritorious. Coleman told Law 360 in an interview on Tuesday, adding that they would not have sued if they didn't believe they had enough evidence to prove actual malice. That's fair. Coleman expressed skepticism that a New Jersey federal court would apply New York's defamation law because Brody is a New York resident, as Boozy's motion argues for. Oh, that's interesting. So Boozy's asking for New York law to apply even though Brody sued Boozy in New Jersey. That'll be interesting to take a look at. I'm sure Nate has covered it over on his channel, Nate the Lawyer. I don't know if he's covering his own suit or not, but he might have covered it. I haven't looked. Brody himself also contested the motion to dismiss on Twitter Monday, pointing to a tweet from September in which Boozy appeared to acknowledge knowing that Brody posted on YouTube under a different name than his real one, potentially demonstrating actual malice. Boozy tweeted, I already knew that this information before I asked y'all for it. So check out Nate the Lawyer on Twitter and on YouTube about this. But I was looking for information on the California bar, and then this Nate the Lawyer headline absolutely grabbed my attention. So I don't see anything on the California bar. A lot of other stuff going on, but I will just close there. I will go look for more from the California bar. Something went down today. I saw it on Jay Edelson's Twitter, so I'll go look for it. But with that, I've been streaming for literally ever. We don't regularly do 4-hour streams. I normally like to stream for like 2 hours. We've just been so busy since I've come back from break that we haven't done that. And then you're like, Emily, you're hilarious because in a few weeks, we're just going to be streaming for like 6+ hours a day. So might as well get used to it again. It's good to see all of you. Thank you for being here. Thank you for being law nerds. Thank you for hanging in there. This has been a lot of fun to break down. It's so wild. Amanda asked the last question I'm going to answer. Can the California bar be sued? In my interview with Jay Edelson, he indicates that he thinks that they can. And so we will see if that happens. So I saw that tweet real time before Boozy blocked me. Boozy blocked everybody. But yes, I saw that tweet too, where Boozy was like, can't even find if this dude's a lawyer. This dude's not a real lawyer. This dude's doing this and this and that. And then he's like, y'all think I didn't know? I already knew. It's in there. I think there's, well, we'll see. We'll take a look at that motion if you guys want to. I'll ask the members. We've got a lot of members chatting to do between now and Thursday anyway. I'll ask the members if you guys want to cover Nate's lawsuit on Thursday, and we'll cover some other things because, defamation feels like a little bit of a lighter case from all of this. This is so much. Tomorrow's podcast is defamation and the Idaho case. It's the Idaho defamation suit. A lot of the members were in the behind the scenes recording on that. It's wild. It's absolutely wild. So I anticipate being back at regular time on Thursday. And if there is a hearing that then is televised, there should be a hearing in Idaho. If that's televised, we'll go over that first, and then we'll go over the rest of it. I'll probably go make a YouTube short, and I'll get this information prepared for shorts on Friday because so much happened today. $22 million, 17 credit cards. Fucking wild. Thank you all for being a Law Nerd. You know where to find me around the interwebs, and I will see you in the next one. Don't forget to connect with me on social media at the Emily D. Baker. You can find all our incredible Law Nerd goodies at lawnerdshop.com. And don't forget to check out The Emily Show and The Emily Show Quick Fits on your favorite podcast player. Thank you for being here. Thank you for being a Law Nerd, and I will see you in the next one.